this appeal. My intention this morning was to run the... Well, surprise. One of my greatest achievements when I was working fully before retiring was to encourage the Scottish Government to have their weekly test of the fire alarm system, not at 11 o'clock on a Wednesday morning, but at 2 minutes to 11, so that this very experience didn't happen. That the very second you start a meeting, the alarm goes off. So that these small things make a difference. So apologies for that, but apparently it is an alarm. So yes, what I was going to say is that I was intending to run today basically on the same basis as yesterday in terms of hours of breaks. Take a break about 11:30, break around 1 o'clock for lunch and come back and close at 4 o'clock today. I don't know what likelihood there is of us finishing by 4 o'clock. I'm reasonably confident we should be able to get through by 4. I won't be more ambitious than that. I have some scope to stay beyond that, but I'm conscious these are quite long days. Other people have other commitments, so we can judge that as we go. I had two issues arising overnight and this morning before we go back to the agenda where we reached yesterday. The first is to welcome Stuart Mail, who's attending today, who is the Compliance Advisor Scotland of FCC Environment. I know there's some correspondence about his attendance and what he can offer us at the third day of the hearing, and speaking to the appellants. I think it might be useful if he was able to speak to the information that was provided at the end of last week, to give a kind of summary of that. And the suggestion for doing so is not to propel him straight into that at 10:01, but to start with the outstanding issues on point 3.4, which I think is where SEPA had asked to say a little bit more. Next on 3.6, which I'll say a little bit about. I don't actually think there's very much more outstanding actually on point 3.6. We'll talk about that when we come to it. And then I was going to, the plan then was to move to Mr. Martin to collectively address items 3.10, 3.11, 3.12, but the suggestion is that Mr. Mail is just slotted ahead of Mr. Martin at that point, so ahead of 3.10, and we can just play it by ear from there. And he can speak about the figures that were produced last week, as read with SEPA Production 23, which is the monitoring data summary also produced in the last couple of weeks. So that's a proposal for the sort of the early part of today, and then take the rest of the day as we go. The second thing I wanted to say from my own reflection overnight was going back to the representations that were made yesterday in relation to item 3.3 of the agenda, and that's the interrelationship between the BAT conclusions and the requirements at the site, and in particular in relation to Regulation 25. And I've listened and noted very carefully to what SEPA said about this. I don't think I need any further comments or representations just now, but I did find, just reflecting on this overnight, it would be useful if parties in closing submissions could just unpack a little bit more about Regulation 25 in its application here. I'm bound to say, in my preparation for this hearing, and it's probably my fault, the way in which the EQS figures interrelated or not with the BAT conclusions was an issue I hadn't really seen coming, I should be perfectly honest. The way I had initially, and I think wrongly, thought that interrelationship worked was something I need to unpack in my own mind a little bit more and understand better. I had come into this hearing thinking that the BAT conclusions were the gateway into Regulation 25, and so the information provided the suggestion that, because for reasons explained, that the review hadn't taken place at that particular point and may yet come, and I asked some questions about what that means for the duties on the appellants, as and when the BATC review takes place. But it would be useful, just when looking at submissions, just for parties to help my understanding in looking at the extent to which Regulation 25 essentially goes through the BAT conclusions, and 25.2 applies insofar, or can apply insofar as a different conclusion from what BAT says, or whether, as appears to be the SEPA position, you can get to 25 without going anywhere near BAT. Obviously there's an issue about consistency with it. So just a better understanding of that, because as I say, I'd initially read Regulation 25 as having the BAT conclusions as a gateway into Regulation 25, and I think that's probably not right in terms of what SEPA are saying. So again, just to ask parties to address that. I mean, I'm happy to have comments just now, but that's just to be clear as to where my lack of understanding is, or how I thought I was going to be hearing representations yesterday.
Sir, for my part, I'm very grateful for that indication, because I too have been reflecting overnight about SEPA's position. Again, the failing is mine. I hadn't fully appreciated it. Perhaps I was lulled into a misunderstanding by reference to the correspondence leading up to the variation, when FCC was invited, in effect, to carry out the derogation exercise we see in 25.12, which of course arises in relation to BAT. I now understand, at least I think I understand, SEPA's position, which I clearly will reflect upon and hopefully provide some helpful submissions for you, sir, to address.
Yes, I'm happy to address that more fully in closing submissions, unless you want me to go through 25 to today.
I noted carefully what you said yesterday, I think, and I've reread Regulation 25 overnight, thinking about it. It's been turning over in my mind as well. It's why it is actually very beneficial having the kind of the contributions to help help me in my thought process and understanding things better. But with that, say relates to that, then I've got the document here.
Perhaps if I could suggest, before we go into the further items under 3.4, there were a couple of supplementary questions that you had yesterday, just in terms of transitional provisions. So if I can provide that clarification first, that might be useful.
Of course.
So the first one was really about the overall transitional provision for this appeal proceeding under the PPC regulations, given that we now have the environmental authorisation regulations. So there is not an express saving provision in the ones, but this was because you'll see actually in Schedule 5 there is an express saving provision, but that's purely for the Radioactive Substances Act, which came in under the 2018 regs. Following discussion with Scottish Government Legal Division after that, we felt there wasn't need for an express saving provision because we have the Interpretation Act. So it is section 16(1)(e) of the Interpretation Act 1978, which provides that general saving provision that allows that any investigation or legal proceeding.
So that's section 6 of the Interpretation Act. This legislation that we're saving, what's it made under?
It's made under the Pollution Prevention Control Act.
Is that an Act, the Interpretation Act applies to, as opposed to the 2010 Scottish Interpretation Act?
So I think in Schedule 1 of the Interpretation Act as well, it defines Act as an Act of Parliament, but then 23A subsection 2B provides that section 16 applies to an instrument made under an Act of the Scottish Parliament as they would apply to subordinate legislation, therefore covering the repeal of the PPC regulations by user. So that provides that link.
I was just wondering whether the 2010 Interpretation Act, whether I should be looking at the 2010 Scottish Interpretation Act, or whether I should be looking at the UK. interpretation of 1978?
Certainly, this position was on the back of advice we received from
Right, okay, I appreciate that. I
SGLD.
understand.
So and they obviously didn't feel the need
Right.
to put an express saving provision in
I'll look
the
at
new
section
regulations.
16(1)(b) of the 78 Act. I can look at. That's fine, thank you. Okay, thank you.
And the second transitional question that you
Yes.
had related to the reference to car in the directions. So just to say, so the sorry, it's SEPA document 2 now. Sorry, no, it's FCC. It's the order that sets out what are relevant enactments. So that has been amended by,
Is that section 2.8, is it? Or is that in the direction?
I think it's the FCC document, sorry. Did we produce it?
FCC 23.
No, it's the Water Environment Relevant Enactments and Designation of Responsible Authorities and Functions Scotland Order 2011. I'm just trying to find what production that is. Sorry, it's SEPA document 3.
Oh yes.
So that has been amended to include the Environmental Authorisation Scotland
Right. Well, that's helpful.
regulations. That was amended by the 2025 amendment regulations.
Well, that's helpful. I'll look at that.
So that provides that the car provisions that now fall under ESER are a relevant enactment under that.
I can have a look at that. I'm not expecting council.
I know.
Quite an instant response to that, but you can look at that if you want to say something.
It's I can tell
At
you
an appropriate time later.
it's sorry, it's Schedule 23,
22.
Schedule 22, paragraph 20.
That's for appeals. isn't
A
it?
and B,
Appeals
which
and
is-
revocations are
yeah.
Schedule 22.
Sorry, Schedule 22 of the Environmental Authorisation Scotland Amendment Regulations 2025, and it's paragraph 20 points A and B that effectively replaces the reference to the car regulations with the reference to
Schedule 22,
ESER.
paragraph 20.
So I can move on to
Move
item
on.
3.54 now. If you- As we heard yesterday from my colleague Olivia about how we go about that process, really identifying the first stage in that process for SEPA is looking at where there is data around that breach of the EQS. I understand that the appellant is not challenging the number crunching under this item and how we've reached the limits, but I thought it was useful still to bring in all three colleagues, Olivia, Andy and Claire, in terms of that process and how we go through that, and particular reference to the guidance, because understand yourself, if you are looking afresh at this decision, you'll want to ensure that we have followed our own processes and procedures here, and also there are perhaps important points to highlight in terms of the questions that arose yesterday regarding that, looking at background levels, looking at the other questions that we had in terms of how that is wrapped into those processes and models.
That's fine.
So I'll pass over to.
Okay, yes. So I'll go through how SEPA determines discharge standards for discharges to watercourses. So what we use is our guidance document, What RMO5, which is SEPA document 17, and its title is Trade Effluent Discharges to Surface Water. And in the guidance it specifically says that trade effluent includes landfill leachate, which is what we're talking about here. And it's the same procedure we've used on many other sites when we're assessing discharge standards. And section 5.3 of what RMO5 says, and I'll quote this, it says, "It is important to realise that it is the impact on the water environment at a local scale which must be assessed rather than assessing the impact on the scale of the overall water body." And then in brackets after that it says the scale of which may be many kilometres. So I thought that was worth mentioning. Assessing at the discharge location. And the procedure itself involves obtaining an estimate of the flow in the watercourse at the discharge location, obtaining the discharge rate itself, which in this case initially we used 500 cubic metres per day, provided by our landfill team colleagues, which equates to 5.78 litres per second as an instantaneous figure. Then I identified the parameters needing modelled, and in this case it was BOD, biochemical oxygen demand, ammonia, reactive phosphorus, dissolved nickel and dissolved chromium. And I just asked our modelling unit, in this case Claire, to undertake Monte Carlo mass balance modelling to determine the 95 percentile, otherwise known as the lower tier standards for each of these substances. And then Claire undertook the modelling and passed the results to me, and then I passed them on to the landfill team. And then they would do the use that lower tier to calculate the appropriate upper tier.
Just explain to me what we mean by upper tier.
Well, in the
See, the tables have upper tier, but no, just explain what that is.
yes, there's two-tier. They're called two-tier standards, which we have when we have a discharge which is sampled. In this case, we have a lower tier limit, and you're allowed to exceed that a certain number of times, depending on how many samples are taken in that year. But the upper tier limit is a maximum that you're not allowed to exceed at all, and that would be a non-compliance. So I think that if you have like 12 samples and you have one exceedance of the lower tier, then that isn't a non-compliance for the permit. You're allowed up to, I think it's 2 if you've got 12 samples in a year.
And that's CEPA 17 is the regulatory method, and the actual figures are they elsewhere, are they?
The figures that came out of the modelling have been put into table 13.
Table at 13, right?
Yeah, which has the lower tier and the upper tier limits for these different parameters. Yeah.
And 13 was adopted, that was originally created in December 2023, but it's been updated twice since then, according to the notes.
That's not relevant to Andy's assessment. That's the EQS assessment that we did to basically trigger the permit review which Andy undertook. So there's two separate stages, I suppose. One is there an impact on the water environment?
That's also in CEPA 13, is it?
That is CEPA 13.
So it's for that purpose.
Yeah, so is there an impact on the water environment? And then that triggers the use of this RMO5, which is CEPA document 17, which Andy follows to edit the numbers within the permit itself. So it was identified that there was a potential risk to the environment because there wasn't sufficient controls within the current permit, and that's why we had to vary the permit with new limits to control these additional substances that were identified. I don't know if that makes sense, but trying to explain the steps, yeah. So we use the EQSs in two instances. The first is to understand if there's an impact in the environment itself. And then the second is using it within the actual setting of the permits, because if by using the EQSs, that ensures the protection of the environment, ultimately, you know, reducing the impact on the environment is the ultimate aim.
I can maybe explain it with the model.
Yeah,
I think when I explain the model to you, it might become a bit clearer.
Okay, thank you. Okay, fine.
Right, so we use Monte Carlo mass balance modelling to, in two modes. There's a forward mode, which you use to understand the impact, the downstream impact of a determinant, which is compared to the EQS to try and understand what the status of the water body would be under certain conditions. And then the second way we use it in backward mode, which is used with the EQS as a target to then identify the capacity within a water course. So that's the two ways that we use the Monte Carlo mass balance modelling. One of the things that I wanted to highlight in terms of the model is that we use it as Monte Carlo, which is a statistical method, and this allows us to add inputs as distributions, so not single values, so it takes into account the seasonality that you mentioned yesterday, because in the model we take statistics of the inputs, which captures all the different conditions, and then that's reflected in the output as well, which comes to us as percentiles. So the lower tier, for example, is the 95th percentile, which basically describes or predicts that in 95% of cases it will fall below that value, but in some cases it could be over, which is why we use that as the lower tier. It allows that buffer for the operators.
And that's why it's a percentile, presumably, as opposed to...
Yeah, exactly, yeah. So it means that we understand that there's certain situations where there would be a breach, but in most cases it would fall below that value, but in some cases if there is a breach it's not going to you know, go against immediately the conditions of the licence. So the SEPA's process of using Monte Carlo mass balance modelling is used across the UK as well. So the software that we use was built by the EA, and it's hosted by DEFRA. So it's an off-the-shelf software package that we use to run the model.
Presumably used by the Environment Agency thing with the Wales as well, presumably.
Yes, they'll run it in on behalf of Wales, yeah. But it's used all across Europe, so that methodology, so not necessarily the software that the EA have developed, but the Monte Carlo mass balance methodology is used all across Europe.
That's helpful. I don't know, Mr. Martin, you were able to say something, but I don't know who on this side of the table would, if anything, wish to comment on what they've heard, either to agree or to disagree.
I can comment.
The comments.
I've always comment.
Happy to do so.
No qualms about the modelling, as we said yesterday. For my curiosity, or the statement of fact, when we're talking about significant impact upon the environment, we're only talking about the water environment. That's what the model does. It's the water environment only. At point B, the data used in the model is purely the leachate effluent, treatment plant effluent quality, even though in reality, at point B, we have the surface water runoff and the RO runoff. So the water, and I don't want to go into discussion on dilution because it's just going to be silly. This is a worst case scenario, whereby if the only effluent going down our channel to that point is a treated leachate. Yeah, that is what's modelled.
Yeah, no,
Yeah.
So the model is actually using some river flow data as well, yeah, so information related to the river flow, so it's not just the leachate
So it's the flow along the receiving water plus the flow equivalent to 5 millimetre cube per day from our effluent plant only,
Yes.
or the effluent plant with the dilution, I'm using that word I don't want to, that may be achieved because the surface water and the RO effluent going down the same channel.
It uses the
Discharge.
the discharge flow.
Yeah.
We,
So it's the worst case.
and the dilution, the existing flow that we've estimated would be in that catchment,
Yeah.
which is, in this case, it's very small, as you're not surprised. It's about 2 litres a second, and it's 5.78 for the discharge itself.
The flow from the leachate plant would actually be diluted by other streams from our landfill site. It's been raining, so the surface water discharge.
I was going to ask that question as well. What do you mean by diluted?
So-
Diluted, presume that means by rainfall.
Yeah, the channel
Could it be other sources as
yeah,
well?
the channel we're talking about, right, so the unnamed tributary,
Yeah.
essentially taking the water from the landfill site. So from the landfill site there are 3 discharges. There's surface water,
Yeah.
so it rains, and there's basic collection system on the site and a system for moving sources. And there's also a existing RO plant dealing with water from an IPA. So on the landfill site there is a storage for incinerator bottom ash on concrete. It rains, water is then contaminated by that material. That water goes through an existing RO plant, and that's then come back. There's a separate table in the permit for that discharge. There's a table in the permit for the surface water discharge. In practice, all 3 go down the same channel to point B.
So could you, I noted on 2 of them, surface water discharge and the water for storage, that the rain, if it rains, it
Yeah, so the
contaminates.
bottom ash is basically the pile of ash. It rains, it's on concrete, that water has to go somewhere. So it's taken through an RO unit to clean off, and the effluent from that is then discharged. It has its own table of conditions in the permit.
And I think I may have seen that in the site
Yeah.
visit.
Hopefully wouldn't. So all the 3 are combined, but in terms of regulatory purposes, what's happening, I'm not arguing because it's stuff. If you take each allowed, but in practice, by the time you get to point B, if it's a rainy day, you've got a combination of 3 effluents, which will reduce the concentration because the other 2 are cleaner than the LTP effluent.
We take into account the we assume the dilution is from the whole of the catchment area draining into point B. So we'll look at that whole catchment area and estimate the flow from that catchment area, and then
Spot concentration used
It-
out effluent concentration.
and then
Yeah.
the statistical model looks at the flow distribution,
That's the-
doesn't
yeah,
it? So it
yeah.
takes into account
It's not, I
wet
think it's an
days.
awkward one because the basic view is you cannot rely upon dilution. I don't say I want to rely on dilution, but it's worth understanding that at point B, it is not just our leachate effluent arriving from our site, it's our leachate effluent plus our RO effluent and plus our surface water if it's been raining. Right, there's 3 different. So the concentrations at that point are lower than what your model will show. Some of the time, maybe most of the time.
That's why
So
the
the
model
model,
takes
the
into account
model
the
uses
distribution.
the distribution of the river flow, which
Yeah.
does then give you the worst case scenario, but it also gives you the best case scenario as well. So that the scenario that you're describing would be within that
Yeah.
output.
I'm not sure it is caught because that's an input into the river, and what we're using in the model are the concentrations. But it's back to principle. The principle is no dilutions allowed. So I get that.
Why do you think it's not caught?
Because what you've got is we've put in numbers of 0.1 or whatever number it is for the ground, but the water actually reaching point B, if it's been raining, won't be 0.1. It'll be something below 0.1 because you've got the other streams in there.
Well, I just wanted to clarify, is it that there's a question around the 2 litres per second estimate for the catchment, is that being called into question in terms of...
No.
Thank you.
Because,
So that will
I didn't think it was the speed of the flow that was
No.
causing the pressure.
It's the
It was sources.
numbers and not the concentration we should rely on today. I went today to measure the flow. And find a lower one. Come summer, I may find that concentration. because there's no rainwater.
I think, Claire knows better than me about this, but the way the Monte Carlo model works, it looks at the whole distribution of flows. You know, we don't just take the maximum or the mean or the low flow, it's the whole range, the whole statistical range is assessed, like we take into account the whole statistical range of the concentrations. We don't just look at the mean or the maximum, it's the whole range of each of the flows, the discharge flow, the flow in the watercourse and the concentrations, and these are all combined together.
Okay, so where I was going from is that the point which you're measuring the distribution from is the effluent from the LTP, not the effluent combined with the other two materials, which will give you a wider distribution and is also much more variable as well. Again, I'm trying not to go into the line of water reliant on dilution, but there is sorry, I want to make sure it's clear that we understand that at point B, the discharge from our landfill site is a combination of 3 different effluents, right? 2 of which are much weaker, much cleaner. 2 of which are much cleaner than the LDP effluent. One is surface water and one is this narrow effluent. So, well, not, as again, the model is the model. I understand how the models work. No crime about that. Where I'm unsure is the upstream point is what? What was the upstream quality? Where is that achieved from?
Yeah, I was provided with an upstream quality which was actually quite, which was basically indicated a clean watercourse, and that's what we used as the upstream quality, and that in effect gives the discharge quite a lot of capacity before it would breach the EQS standards, so that's to the benefit of the discharger basically. So we assumed that there was a low level of contamination upstream.
Yeah, so that was within, in effect, the Cameron Burn upstream.
I believe that was WPH.
That's what
It's the upstream one.
Yesterday.
Yes, yeah.
I looked at the evidence that, I never forgot who provided the evidence, but I was taken through the assessment of the report, and the upstream testing point was WPH, which I think if we concentrated on phosphorus had a much lower level of phosphorus presence at that point. That's what I took from what I was told yesterday.
We use
Well, just anything else you want to say about it?
I'm just checking.
Just check.
pH is upstream of Cameron Burn, so okay, I can understand that.
Yeah. Yeah. Right.
May I just add another point of clarification, and please correct me if I'm wrong, but at the time of the Colmart report, the IBAA plant wasn't in place, so that wasn't a relevant discharge into the modelling exercise at that time. It is relevant now, but it wasn't at the time of the modelling exercise.
This process has gone a long time.
Yes, and also there wasn't any surface water outfall data provided to SEPA at the time of the Colmart kind of report. It wasn't included or considered in the Colmart report itself. So I just wanted to clarify that as well. That they concentrated on the treated leachate discharge and the impacts on the water environment without taking account of the surface water discharge.
Which we would do because you take a worst case and it doesn't always rain in Scotland. Yeah. So we'll always provide the worst case data model on that. But in terms of what you saw when you went to the site, you would have probably seen a mixture of waters going down that point to join point B.
Yes, absolutely.
Assuming you didn't.
Simply by eyeball visualization, you can't tell.
Yeah.
That is entered into the tool is the WPA data, so that is the treated leachate discharge. So that's what's entered into the model, and then the flows take account of the input and then the catchment wide flow. So the discharge flow and then the catchment wide flow. So the discharge flow is 5.78 litres per second, and then the catchment flow was 2 litres a second was the estimated, as Andy had said.
Is the catchment flow, is that WPB?
Well, yeah,
Discharge flow
it's
is
in the region of WPB, is in
So
the
it's
catchment, it's representing the catchment, yeah.
It's just on the catchment flow. Do we the figures get 5.8?
5.78, I think. it was
Yes,
on
that's
the-
right, yeah.
on the
5.78
reference that we're talking about.
And 2 litres per second for the
I think you said that.
Is the
catchment. Yeah,
Is the Q95?
yeah, that's the low flow.
That's the low flow value. 2 litres per second is the low flow value from the catchment. Yeah. But again, in the model, we use the low flow value and the distribution around it as well. So
There's more to come.
yeah,
More to use.
But the low flow value would be prior to B. Yes.
That would be,
The 2 litres per second is prior to B, so flow in the catchment.
Yes.
Prior to point B.
yes.
At point B, we have a combination of the leachate effluent, nowadays the RO effluent, and potentially the surface water effluent if it's raining. So the 5 litres per second is purely leachate. In actual fact, there's more flow going there, but it's more dilute than your model says. Because there's more flow in, but you wouldn't catch that. You've measured before our discharge point. Here's our discharge point. It has leachate, it has surface water, it has IBA water. We're only considering the leachate and the concentrations in the leachate. So the flow there is greater, the concentration must be lower. But I can't rely upon that because it doesn't always rain in Scotland.
Anything else on that? I don't know if anybody other than Mr. Martin wants to talk on that particular issue. It's been best qualified on my mind.
No, just
But that's it, yeah.
just to say that it was based on the data that was provided at that time, which was the leachate treatment effluent. There is the effluent coming from the RO plant now that's in the separate schedule of the permit, and that is got the same discharge point. They
So
can
discharge points is the same. But that is how you find that explanation of the background of all of that.
Charge them as one, they have to be regulated separately.
But they go out the same point.
Same point.
Even if they go at the same point.
Physically, they're combined.
Yes.
They're going out the same point.
They come at the same point, but they're regulated at different points of time.
Yeah.
On what was item 3.6 of the agenda. I think most of the issues there, just thinking about that, have probably been covered partly by the representations that were made yesterday, and there has been reference to the email chains that are now produced for 2022 and 2023. I think I probably had put that in at the very beginning of the development of the agenda when I was thinking that one of the issues that the appellants were taking issue with was the fact that there was a pile of documentary evidence that wasn't shared with them at the time the decision was made, and I was wondering at that stage whether there was a procedural fairness issue that was concerning the appellants at that point. To a certain extent, I think things have moved on, not least because from both sides there had been other subsequent documents that have been provided, and the relevant documents concerned are now before me. So I think that issue is maybe a little bit moved on, though again I'm happy to hear suggestions to the contrary. So I think most of the reasons why I'd prepared that as an agenda item have been covered either yesterday or previously, but nevertheless, if I'm not right about that, I'll maybe move to the appellants first of all, just if there is anything further I need to note or be aware of under those headings.
Thank you, sir. The reason that the comment was made in the response for the appellant relative to these documents was that A, they weren't produced in the response, and B, so far as SCC were aware, albeit reference may have been made to them in passing, as it were, in the correspondence, a full suite of documents had not been produced. However, no issues taken now, and we're having an ecology session anyhow. The point which was being made was that SEPA appeared to be relying wholly, so far as the variation was concerned, on their, my words, and I don't wish to insult their reductive reasoning, there is an excess of the EQS, therefore the variation. It did appear that the decision making was, having regard to the response, a bit more nuanced and took account of ecology as well. We had a discussion yesterday which for my part I found illuminating to an extent at least, trying to understand exactly why it is that SEPA effectively say EQS or within this self-defined local water environment area. And no doubt I will make submissions in relation to that. But for my part, as I say, sir, I have found the discussion yesterday of some assistance to understanding SEPA's position.
I think our position has been set out in the response on the joint note at point 8.1. There's lengthy correspondence. Obviously, this issue has been going on for a number of years. So while those documents weren't provided, these are all documents that were in the knowledge of the appellant and have been referred to in that correspondence. So around our decision making that relies on both the ecology but primarily the chemical data, which has been for the basis of as we've set out that process that initiated the variation. So I think I've dealt with each document in turn in that response. I won't go back through them. I would just perhaps like to add though, in terms of there were comments made yesterday around the I suppose the appellant expressing surprise when they received the draft variation that it included limit values and that this was the first that was known to the appellant. You'll see from the correspondence as well, there was over a year of correspondence that followed that. So again, that, you know, and there had been meetings prior to that discussing various options to address the issue. So in terms of allowing that fair procedure and involvement and the discussions between parties, it's been a lengthy process.
Data summaries that are provided that I got on Friday of last week, which, as I say, I think there's 3 sets of documents I think we're looking to look at just now, which are documents FCC 43, 44 and 45, dealing with first, second and third quarters of 2025, and the versions I've got have these. It's on a kind of Excel spreadsheet with various kind of headings that you can navigate around the bottom to go from one to the other, and so that's something that would be useful to be sort of guided through to get an understanding of that from the appellant's point of view, if that would make sense. So just again invite a kind of narrative discussion to make the points that you want to make about that information.
So just to give you an overview, these 3 documents, the Excel sheets, are the landfill emission returns forms that we submit as basically as data returns to SEPA. So prior to 2025, I believe they were introduced a couple of years ago on a in April, and from April we use these forms to submit data for 2025. The requirement in the permit is that we only now submit data where there is a numerical limit, and not all data collected as required by the permit. All data submitted as part of the annual return once a year, which for Greengairs is in July. As you noted, there's various tabs along, so there's one for each section: perimeter gas, leachate depth, and I was asked to look at these in relation to the appeal for the tab that's treated leachate effluent, and we make 2 submissions, or 2 locations, sorry, within that, which is water point 1, which is the treated leachate discharge from the landfill, and in terms of the investigation relating to the appeal, that's water point A. And then the second point is Greengairs water point 15, which is the treated RO reverse osmosis effluent, which comes from the IBA pads. And again, where data is submitted there, it's only in relation to where there is a numerical permit limit. I was asked to look at that in relation to, I think it's evidence document 23, which was a table of a summary table of data submitted by SEPA as part of the evidence, which where data is there numerical value, it reflects the information that I submitted in these LER forms. The data runs to September because the Q4 submission hasn't been made yet. It's due on the 15th of February this year. And we just had some questions around where it says no data submitted. Generally, I think with the exception of one reactive phosphorus point in in June, there's no requirement within the permit for us to have submitted that data in the LER forms. And also where there's D/D, we weren't sure what that referenced, because there's no note in the key.
I hadn't spotted as a D/D, I'd spotted as an N/D. N/D describing no data submitted.
I think perhaps that's just a typo. I think as we confirmed yesterday, I perhaps gave clarity that we weren't suggesting there was missing data. We recognise that some of the data is submitted on a monthly basis, some on a quarterly. So no data submitted doesn't mean it's missing.
Yeah, I'm understanding there's no intention to suggest there's a pejorative or critical aspect of that. The monitoring point ID that's referenced there, you refer to 1 and number 15 reverse osmosis. Where are those monitoring points?
So,
We have maps here.
and they're just at the end of the leachate discharge rebeds.
Oh, right, okay. So, yeah. So is that point A?
Yes, it's point A.
It's shown as point A.
So in that investigation where it was point A, we used the discharge point, isn't it? The RO discharges into a very similar location, approximately half a metre from the VNOx that's used as the discharge.
At that discharge point. So that's number 1, yeah. Number 15?
Sorry, they both discharge.
They both is a fine, thank you, yeah.
Within half a metre of each other.
All right, okay, oh, I see, yes. There you go.
If you look at the permit, the two tables actually have the same grid references for both the sampling point and the discharge point.
So they're as close to each other as that.
Yep.
So we're just trying to look at this. This is quite helpful in the sense of looking at where the figures are the same. So I'm looking at the nitrogen figures here. I see a reference to 0.45 and 0.27 and 0.2. So that's helpful from that perspective. If I'm trying to work out what the figures should be under the other headings where no data is indicated by SEPA, and the first of that is reactive phosphorus.
So that's, as a result, the permit variation only entered into force in April. So that's why for those 3, January, February and March in 2025, there's no requirement. Because the table 12...
No figure to go there, but
no.
That's fine.
The table 12 limits only entered into force in April. So that's why there's only figures from April onwards.
So I suppose my question is, what's the best way for me to take information from what Stuart has produced in order to understand the overall picture? So I think what you're saying is for reactive phosphorus, for reasons explained, this data here produced doesn't give me a figure. To add to that,
So,
this
this summary table provided by SEPA was pulled together from this submission from the appellant. Yeah. So I don't think there's any discrepancy between the two. We've just pulled it into a summary table that covered the parameters.
That's helpful. That wasn't the
No, I think where there's a numerical value, we're in agreement. It's what was submitted by ourselves. It was just around where it says no data submitted. It reads as if there should have been, but yeah, there's not a requirement to have done it.
And I'm just matching up. Yeah, that all seems to match up. Looking at the document 44 as well. And then April. Okay, that's helpful. I mean, the key important thing for me in all of that with the tabs in the bottom is actually just getting an understanding of which tab to look at. Because obviously with 5 tabs, I was sort of navigating between various of them, and it wasn't immediately obvious which was relevant to look at. So that in itself is very helpful just to draw that out in terms of those figures. But I think as you're saying, there's nothing that's inconsistent in terms of the figures. And a brief glance, I'll look at it in more detail at leisure. But that seems to be sort of consistent figures from that point of view, and that's the most up to date just now. I'm not sure about whether this is beneficial to try to navigate between these documents. My other question that's in my mind, bearing in mind that there are these are 3 successive quarters, is what if anything the trends are in the figures. But I can see that from CIPA 23. Just as time goes by. I have a funny feeling that we're maybe to a certain extent potentially drifting into evidence we heard on the 4th of March as to what the meaning of these figures actually are. So happy that we're clear that there's no disagreement of the figures. But looking at the CIPA document 23, I can certainly see numbers that are there that are varying as time goes by, and the question in my mind is the extent to which these represent a trend on the monthly sampling, and whether that's of any significance. But is this something that is really for later
I was
to assess
perhaps
or
just
to
going
interpret?
to add in terms of trends, and it might be useful if Mr. Mail can speak to if there's been any results, because we understood that there was a trial that was undertaken in July on using the reverse osmosis unit to treat the leachate, and just to see if there had been any trends or results that had come out as a result of that.
I was going to ask
if they'd
anyway.
Seen any sort of changes in the data following that?
I was going to ask more generally about later on about reverse osmosis, and to have an explanation of what that is and what that means as part of a sort of remedy. If there is a problem, what remedy? But Mr. Martin looks so he's going to
I could answer that question. I'll do the arrow lecture later on.
That's fine.
We ran the trial, I think, for a day, just to prove some data, so we know. So in terms of the overall impact on the site measurements, it's none. You wouldn't have noticed.
On my question of how do we interpret that data, is that something we'll be addressing later? And as they're looking at kind of what these figures actually mean, what they signify, and whether they don't look like there's trends, particularly they look as if the figures, sometimes they're quite significantly different from each other, and whether that has any significance. I'm just looking at the BOD.
We haven't done a comparison of that data against the EQS, so it would be very much on the hoof today if you wanted
No,
that.
I'm not asking you to do that.
We provided this data just to show in terms of, we now have that monitoring that is a requirement under the permit, so we do have that data on these 3 parameters now, and it's just to show that there is still an ongoing issue. It's not that...
Your point is there's an ongoing issue, you say. You're not making any suggestion as
No.
to whether it's getting better or worse?
We've got the table 12 limits in the permit now, which reflect their ability to their current treatment at the site, but that is a long way off what would be required to meet the table 13
You
limits.
say the far short anyway.
Yep.
I don't know if Mr. Martin has anything. Do you want to say anything about that issue?
The current plan will not meet table 13.
What is it?
The current plan is a long way from meeting table 13. That's why we're having the debate over our row.
There's three kind of grouped questions that I'd put on the agenda at 3.10, 3.11, 3.12, and these are all to do with extraneous factors and concerns that I think the appellants have, that if you look at the bigger picture in terms of the environment is not being fully factored in the exercise of discretion and the application, if you like, of a sort of proportionate approach to what's being done. So perhaps clustering these three together, do you want to say something about what your concerns are as to SEPA's approach to these issues?
I'll start with a question. Can you take me through how you do a carbon assessment? You talked yesterday about, you looked at what we offered and we made a comment about the carbon emissions were high, and you said, and you've responded having elsewhere, that you took into account carbon. How do you do that? How do you take into account carbon emissions? We're talking about best practical environmental outcome rather than just water quality here. So how do you do it? What is the mechanism?
Would you like me to come back on that, sir?
If you can do it.
So first of all, the reference to best practical environmental outcome, I think that has come from the reference in our guidance, which we are, I think, due to discuss under item 4.2, the WAT SG 68 guidance that looks at alternatives, and I don't know if it would be helpful then to discuss that first to show that this doesn't apply in this case. That was provided really just to be helpful in considering it, looking at alternatives, looking at the different treatment options that the appellant might consider. The correspondence shows there's been a lot of different options that have been on the table through discussions over that year after receiving the draft permit. But and I'll ask Andy just to come in a minute just to explain what that guidance is. That's really around a derogation process under the Water Framework Directive, which doesn't apply in this case. So that, yeah, the guidance was just trying to be useful in terms of helping them, but ultimately we put the limits in the permit. We do not specify the treatment. That's not for SEPA to do. That is the operator's choice, and for them to look at other aspects such as carbon, such as cost. We've got a duty to set those limits, and we leave that choice of treatment to the operator.
I was wondering, that was the reason why I was wanting to ask the question there, because I thought when I saw that document on document 68, WAT SG 68, I was kind of expecting to look into that document and see something that led us into a conversation about the sorts of things that the appellants would be suggesting as a means by which they, in a proportionate way, can satisfy the regulatory needs. But when I got into the document, it didn't seem to be about the same thing at all. So that's what I wanted
So
just to clarify, whether I misunderstood it or...
If I may, the appellant were invited by SEPA to look at alternatives, and they did refer to the guidance, and that is referenced in document FCC 9, FCC 8, the letter from AISA to SEPA dated 23rd April 2024. So this was a matter which the appellants were in terms directed to and asked to consider. So insofar as any criticisms be made of FCC in looking at this matter, that was at the invitation of SEPA. Clearly we'll come on to consider under Chapter 4 of the agenda items the scope to consider proportionality, etc., etc. Though I suspect that's as much a matter for legal submission as anything else. But clearly it's the appellant's contention that one does require to take an overall approach, proportionate approach, squaring up the risk to the environment overall with the costs, both to the environment and to the operator. And to that extent, whether the guidance is strictly relevant or simply referring to derogations, it seems to me that it might be a useful framework, at least to consider the issue of proportionality if you, sir, come to the view that proportionality is something which you can properly take into account. But the wider issue, which I think is foreshadowed in agenda items 310, 311 and 312, is to consider, at least so far as the appellant is concerned, what they consider to be wider harms to the environment beyond the local site, and I'm emphasising that because SEPA emphasised the words local site, or beyond the site more generally. And I suspect that Mr. Martin does have something to say about that. Whether ultimately you decide that is relevant or not is for a later session.
To repose that question and ask again, as a kind of prelude to going into your discussion about the other issues.
I'm not sure I can repose the question because I'm struggling. The Scottish Environment and Protection Agency doesn't consider net zero. It's not actually a measure we can take into account in deciding what equipment we build. That seems strange. I cannot build anything in Scotland now without doing a carbon impact assessment or potentially being challenged by a lawyer over not having done the carbon impact assessment. There's some pretty good laws on it, so I'm a bit puzzled by that. That it only matters if we were to go down the degradation approach, but that doesn't seem right. You surely have a duty to the environment as a whole. So I'm not sure that's a question, it's just I'm puzzled.
Treat it as a question, is it?
Yeah, I'm perhaps a bit puzzled by the question. It's absolutely open to the operator to do that carbon accounting themselves, and we would expect that. We are in no way preventing that. We do consider net zero, as we discussed in yesterday about our overall climate change duties, but that would not require us to go in and do that carbon accounting assessment of the technology that they're going to use.
So the question then comes, having done the carbon assessment, in our view, we felt the carbon emissions were quite large, right, for what the benefit that may be achieved. How do you decide the carbon emissions were not too large for the benefit that may be achieved? What's the measure? How do you do? How do you use that balance?
So how do you work out what the carbon emissions are? It sounds as if your perspective and your view would be different from SEPA's.
Yeah, so...
Sorry, sir, I wonder if I can interrupt here. We may be talking at cross purposes. As we know, the appellant has carried out its carbon emissions assessment, and that is featured in the correspondence. The point that the appellant makes, and again this is perhaps a legal point as much as anything else, is we know that SEPA apparently expect an operator to do that, but how does that figure in their decision-making process? And I think the short answer may be it doesn't so far as discharges are concerned.
Would you like me to confirm here? So I think we've, as we set out yesterday, you know, it's very much for the appellant to choose their treatment option. We haven't specified that, so we wouldn't look at that individual assessment of one treatment option. There is still a number of treatment options that are on the table. We're not, as far as we're aware, they haven't decided on what treatment option because pending the outcome of this appeal. So there's not in terms of our decision making and putting in place those limit values, that has not come into.
In the submission we said the only technology that could achieve this is RO. We then went down the line saying why we think RO is not good enough in terms of the overall impact upon the environment. You've then come back saying we want these numbers met, but not told us anything about your view of that impact upon the environment as a whole. You keep telling me it's my problem.
I wonder, rather than turning into backwards and forwards argument, which may not be very productive. As we know, SEPA have set the limits the appellant's contention is that to meet those limits, that will have certain carbon emissions consequences. The appellant invites you, sir, to take that into account. SEPA say, as I understand it, we've determined that these limits have to be met. There may be carbon emissions consequences, but that's for you, the operator, to work out. I hope I'm not doing disservice to the argument.
No, subject to saying, I referred to our overall climate change duties yesterday, and obviously there's 3 strands to that, and there's sustainability, clearly, and that is part of SEPA's statutory purpose already. And looking at sustainability, part of that is also compliance with environmental limits. And I think if we go back to, this comes back to, again, the basis on which we have put these limits in, based on the EQS, for this discharge, this point source here, and the steps we've gone through to do that. Perhaps it would be useful when, I don't want to go back into all the detail of that decision making and how we got to that and the basis for those directions, but I'll set those out in further submissions. But it's useful if I could just refer to, there is, alongside the standards, we also have a policy note that comes from Scottish ministers into how we are to do this. And so, as Olivia mentioned yesterday, there is the new 2014 standards, and that has a policy note, but there is also the earlier version, 2024, there's also the earlier version for the standards that we were applying in this decision-making process. And that clearly sets out this dual purpose that I was talking about yesterday about the application of the standards. And it's got useful, it provides guidelines to SEPA as to how we are to apply those environmental standards in placing condition limits in our authorisations. And it sets out, I'm just going to, if I can just highlight some of the principles. So we will be expected to use our powers to prevent a failure of an environmental standard or condition limit, and that would include refusing to grant applications to undertake controlled activities that would individually or cumulatively result in failure of an environmental standard or condition limit. So if we were looking at this installation afresh as a new application, it is likely that based on the discharges it couldn't be authorised. Obviously we're not looking at it as fresh, it's a long-standing landfill here, but changes, science moves on, we've had changes in those standards, but we are required to apply those standards. When we get on to that policy note also sets out the sort of steps that we would be expected to go through, and it's useful to say, first of all, it sets out about how that, again, reflecting the whole process that we do for all of these types of authorisations. First of all, comparing that monitoring data against the environmental standards, assessing confidence of results, and then looking at that, how that would translate into putting a condition into the permit. When we get on to then the practical application, it also covers off these guiding principles. It's very clear that the ministers expect SEPA to follow a number of steps. That is that the relevant regulators, SEPA here, identify the activity responsible for causing the significant adverse impact on a water body, that we seek the necessary improvements by encouraging or initiating a variation of the relevant authorisation, as we've done here. And then it goes into looking at taking necessary action to deliver the environmental improvements where they're disproportionately expensive or technically infeasible. And that's where that derogation route again comes in, as is in the guidance. But other than that, we don't have that wider, it then goes on to that we issue the appropriate period authorisation.
I'm sorry to interrupt, Ms Armstrong. This is very interesting, of course. It would have been extremely helpful to have seen this document earlier. It might also have been useful when the appellant was referring to or asking SEPA to take account of carbon emissions in the correspondence if similar points had been made. I am slightly concerned that I'm not in a position to respond to this. And I have no difficulty with Ms Armstrong referring to this, but could I just flag up I reserve my position on this?
and I apologise for that, sir. Obviously, as I said yesterday, through the course of this appeal, the argument presented by the appellant has changed in respect to the application of the directions. So this was not covered in our previous written submissions. And as we said yesterday, in setting out this, in addressing the other challenge that they had to the application of the directions, we need to provide more written response than that. And certainly, I can provide this document and include that in it.
I suppose the thing that's in my mind is the question about if you like, the chronology of the provision of information, how that plays into what those obligations are. What I'm taking from SEPA's perspective is that whatever the outcome, you can't go below the EQS scores. And what I'm trying to work out as to whether the adverse carbon impact, I can't see how that can play into the scores. And so the question then is, while wider carbon implications I can see could be relevant, because it's obviously it wouldn't be a great outcome if an unduly rigid approach was applied to the appellant site, which had that wider consequence. It's quite difficult to see how that plays into an assessment of the fundamental duty of SEPA to achieve these results. And that's a different issue from, I think, what I would like to explore, and in particular, the kind of costings of that, of seeing that if the only way the levels can be achieved is by disproportionate cost and disproportionate works, and I'm very interested in that aspect of it, how that plays into proportionality. Those are two separate things. I suppose one of my difficulties, not just on the kind of the guidance which is not available, but the evidential basis of looking at the wider adverse carbon consequences. I think certainly the appellants say that they believe there's an adverse consequence, but it's quite difficult, I think, for me, on the basis of what's before me, to kind of quantify that and make a decision as to how that impacts on the obligation to meet the standards in the first place.
Well,
that's maybe no more than the expression of my dilemma, and you may say, well, tough, that's your job to do that.
Well, if I can just say, I suspect Mr. Martin just wants to talk about the facts, as he would have them.
Yes, and that's fine.
Clearly, it would be a matter for you, sir, what you make of that evidence. As we know, for the reasons expressed by SEPA, they have not considered the position as the appellant would have it, and it would be a matter for you, A, whether it's relevant, and B, what you make of it.
You want to talk about the facts then?
No, where it sort of comes down to is the significant pollution. We're talking about a point B, where we fail EQS. The argument we've used in our chemistry arguments and in the ecology arguments is that failure doesn't last very long because of our inputs into the water, and then further down the quality actually goes backwards again through other inputs, which may be from the village, may be from activities, it may be from natural sources such as mine water. So we're talking about a small length here, and that's where the significant bit comes in. I accept the point about EQSs should be passed, right? But sometimes in achieving that pass there are consequences, and then the issue then is that a very high quality water where the damage is massive, or is it a low quality water where the damage is actually negligible? And that is a instinctive emotional argument rather than a financial numbers argument. And that's a bit, it's easy to say you will meet the EQS at all times. It'll be very easy in permitting to put EQS standards on every discharge in Scotland. That way you'll be sure that the water will meet EQS. But the cost of that would be massive if there was any Scottish industry left. So, you know, you need that bit. So it's down to this issue of what is significant or not.
Does that suggest that the question of working out what the EQS standards are is not solely a scientific or arithmetic exercise, but is something that should, before they're even set, should take into account the carbon implications elsewhere? Because if it can take into account the other implications, then SEPA can reach a view that the standards that are set and must be met already take into account these wider carbon. Is that effectively what you're saying?
My opinion would be the problem we have is EQSs predate the concerns about carbon. EQS system has been there a long time. So what we have is we're not keeping up with the new worries.
To comment on that, that's a very specific issue. I understand the point you're making. It's a very specific issue.
So if I can comment first on Mr Martin's point about applying the EQS to every discharge in Scotland, that is how we do it. That is, every discharge in Scotland is assessed the same way as Andy and Claire have set out here. So the EQS are applied as we are directed to do by the Scottish ministers. I think Olivia's going to add something just about in terms of how the EQS are developed and where they take into account carbon.
Well, I mean, I've not been involved in actually deriving the EQSs. These are generally derived either at a EU level or a UK level, which is a cross-agency group. In terms of whether they take account of carbon, I can't fully comment on that. Just to explain that, as I mentioned yesterday, there's ecotoxicological data that is used to understand the level at which the environment is impacted, the ecology is impacted, based on those criteria I mentioned yesterday. The algae or bacteria, crustaceans and fish are kind of used as markers. But in addition to that ecotoxicological data, there's additional factors considered about the implications of introducing a certain number. So if they were to introduce a number that would be exceeded right across the whole country, just based on natural levels of these chemicals within the environment, then that would do a disservice basically to every industry in Scotland. And as Mr Martin has pointed out, you know, there would be exceedances right across the country. So as part of the decision making of how those EQSs are developed, there is a kind of additional factors that are considered in terms of implementing certain numbers, so that they're you know, protective of the environment, but also reasonable to implement, you know, in terms of balancing those two things. I don't know the full extent of the decision making of how that is factored in, but there is generally an implications assessment that is carried out. So if I may go down a slightly more technical route, a PNEC is something that we use as a term for a predicted no effect concentration, and that's a number that is purely based on the ecotoxicological data, and we sometimes use those in the absence of an EQS, a statutory EQS that's available, to introduce a limit within a permit, so that the environment is protected for substances that have no official EQS, but we know that would still have an impact on the environment. So I use a kind of example. Explosives are something that has been, you know, released into the environment. MOD sites, for example, they don't have an actual EQS within the directions, but we still know that they have the potential to have an environmental impact. So there's been PNECs developed for those substances because of that. When that PNEC is usually fed into the process of how this EQS number is finally derived. But as I say, there's these additional considerations in terms of the finalisation of the EQS, which take into consideration wider implications of introducing such a number. So I just wanted to kind of tackle that point.
The thought that's in my mind, just listen to that answer, I know you're not claiming any expertise on the detail of how, if you like, the EU-wide determination of the framework takes into account carbon factors, but I can understand that at that EU level, viewing the world from Brussels, I can see that account could or would have been taken into account in setting frameworks of wider carbon issues. But what I take Mr Martin's point is to say that when it comes to the carbon implications of this particular site, that can't be done at a central basis. So there's a difference between the macro and the micro. And while it's I know you're not claiming it is because you're not claiming expertise. I'm sure you're right that in the determination on an EU-wide basis as applied now to the UK, those wider macro factors are taken into account. The question I guess I'm wrestling with is how that can be taken into account more locally to consider the points that I think are being made in the appellant's case in relation to these more localised examples of where there are carbon-related disadvantages because of what you're not proposing it, but what the appellants would say they're required to do because of what you impose.
Sir, and I wonder if it might be helpful to refer to the correspondence to look at the micro level. And the appellant's arguments are first articulated in FCC 8, letter from AISA to SEPA of 23rd April 24.
Yes, absolutely.
It's a lengthy letter, but it might be useful for you to...
I think I've got that plastic in front of me. Yes.
Thank you, sir. And you'll see in the first page, again, we see reference to SEPA inviting the appellant to consider the guidance to which we're now told is not relevant. There you have it. For perhaps understandable reasons, the appellant did take up that opportunity, although now we realise it was a waste of their time, perhaps. Then the introduction and the matters summarised in the last paragraph. In order to meet the changing conditions, an additional process stage will be required, or the entirety of the treated effluent must be tankered off-site to suitably licensed wastewater treatment works. And then the supporting guidance, which we've heard about, is flagged up, and then there's another guidance document referred to. Let's see. And then in section 2, there is the options assessment set out. First of all, the author notes the overarching objectives of the guidance, and the contention is that guidance, brackets we now know it's a waste of time, in the author's opinion was met, and there's reference to the good quality status, and we've had that argument or discussion. Proposal to reduce the quantity, alternatives are cost prohibitive, and there's further information later on in the document about that. There would be a significant direct increase in carbon emissions to power additional treatment elements, and significant additional carbon releases for the off-site tankering that cannot be discharged. Then there's reference to what the appellant contends would be the water quality effects. And this is by reference to the guidance. The author is just picking off or addressing each item. Then over the page, there's reference to reverse osmosis. And you may care to note, and this is the appellant's contention, and Mr. Martin can no doubt explain a bit more if necessary, but the appellant's contention is that RO is the only technology capable of achieving the proposed discharge limits in Table 13. But then, after looking at the table, the contention is that RO is energy hungry, and that is explained. So,
which table is this?
sorry, Table 1, which...
Table 1. Yeah, the figure 1.
Sorry, I'm on internal page 4, section 2.3. And the contention is that RO is the only technology capable of achieving the limits in Table 13, and helpfully, brackets unhelpfully, the authors reproduced that as Table 1. After reproducing the table, it's submitted that RO's energy hungry.
Yeah.
And then in the last paragraph in that section, it said, RO therefore reduces the quantity of the treated effluent, which must be tankered off-site. The alternative is to tanker the entirety of the leachate if the discharge is deemed unacceptable to SEPA. Then there's a cost appraisal, and that's based, you'll see, sir, on the experience of the appellant. Now, we know from yesterday's discussion Mr. Martin doesn't have any objection to the figures being mentioned. I don't think I need read them out, but the submission in short is that they are, on any view, considerable. The capital costs are set out in Table 2, and the annual operating and concentrate management costs for the reduced discharge being suggested are set out. And then there's a cost projection provided in figure 1 over the page. And then a 20-year cost production in table 4. And you'll see that's on the basis of a reduced, 300 square metre per day reverse osmosis plant to achieve the table 13 limits. Then in 2.5, section 2.5, I used to address other factors. Implementation of RO is both power and transport intensive, requiring a 40.6 mile round trip to Grangemouth. I wonder if I might just flag up Grangemouth, because I think Mr. Martin may have some information to provide on that, but if I can just continue with this letter. Both of these factors will also cause a direct increase in carbon emissions, and you can see that an additional carbon budget is being calculated based on UKG greenhouse gas reporting conversion factors. And first of all, we see the transport carbon budget at table 15. And then the RO plant electricity demand carbon budget. It's suggested that to implement the draft permit conditions, the management of leachate will require 24 tankers over a working week. And further information about the electricity demand is given. And then the matter is summarised in section 3. And the response to that is in the next document, FCC 9. Where SEPA Bertiv reviewed that case. And perhaps a familiar refrain now from SEPA to the effect that the treated leachate discharge is causing a breach of environmental standards in the receiving unclassified water body. The ecology team have conducted regular sampling and concluded that the leachate treatment discharge is having an impact on the unnamed tributary of the Cameron Burn. They are required to periodically review authorisations, etc. Then over the page, it said that the appellant directs SEPA to section 5 of the guidance. Well, actually, in fairness, that was in response to SEPA's request, but leaving that aside. SEPA then going to say the letter only then provides the cost information for the installation and operation of the RO plant. You, that's the appellant, indicate that the RO plant is the only option to achieve the proposed discharge limits, and then provide a cost appraisal for this, which you indicate is disproportionately costly. The submission did not contain any information on other significantly better environmental options. So I'm not sure what SEPA's position is on those figures. It's just, well, we see the cost of proposal, but what about other options? Which, to be fair to ICE, they go on to address in further correspondence. But that's on the back of the appellant's contention that RO is the only process to achieve the permit limits, which I don't think is disputed by SEPA. Then there's a discussion in that letter of the proposal to reduce to 350 square metres per day the discharge rate, and then a further reduction to 300 square metres a day. The contention is that these still could not be met by the current leachate treatment process. Then, moving forward, this letter advises us that SEPA would be happy to discuss significantly better environmental options with you. As part of your optioneering, if there is no significantly better environmental option to meet the requirements of the new permit template, it is necessary to consider whether there are any improvements which could be made to the water environment to achieve a lesser improvement, etc. So, in the next document in the journey, that's FCC 10, IESA respond to that. And they suggest carbon filtration. SEPA's response in the next document in the bundle, document 11. They acknowledge the proposal for carbon filtration as a polishing step, but are still of the opinion that the treated leachate discharge is causing a breach of environmental standards. So they come to the view that that will have little effect on the leachate composition. IESA respond to that. In document 12. And in this document, in this letter I should say, the topic of, well again they repeat the contention that the environmental and financial cost of achieving the proposed limits are disproportionate and not justifiable. And they then reference 2 other permits. And again, I think Mr. Martin will want to say something about those. Then on page 2 of this letter in document 12, the appellant identifies a number of potential resolutions, including diversion of the discharge route via pipe connection, ecological enhancements to the upper reaches of the tributary, a reduction in volume, an environmental and cost-benefit assessment for diverting a part of the effluent to an RO plant with off-site tankering to the Grangemouth treatment works, again flag up Grangemouth, and the introduction of carbon filtration post the on-site reed bed stage. Then the appellant's understanding is provided to the effect that SEPA didn't favour the first of those 2 above approaches, namely pipe discharge and ecological improvements. If in error, please let us know. And then the contention that there's no ecological detriment to the tributary to the Cameron Burn caused by the discharge of the leachate. But given the concerns raised, they are of the view that a practicable resolution is through ecological enhancements, which are then referenced. And SEPA refer to that in document 13, which is the document which include a letter dated 22nd January 25, which attaches the proposed variation. And you, sir, I'm sure will read this in some detail, but this is the first time we see reference to the directions, which we heard something about yesterday. Referring to the water classification discussion which we heard yesterday. Then explaining that the limits have been derived using the Monte Carlo mass balance model, which you, sir, heard something about this morning. Saying that, in short, it's comparing apples and pears to look at other permits. Then the 2-year implementation period to Table 13 is intended to give the appellant time to consider and put in place arrangements which will enable them to comply with the revised limits. And then they address the various proposals so far as diversion, it was SEPA's understanding that operation was not feasible due to land ownership and access issues, but you may still wish to consider this. Ecological enhancements. The short point made by SEPA is that enhancements won't improve water quality, which wasn't really the point which was being made. And then discussion about there may be some proposal to build houses. Then reducing the volume. And then picking up the environmental and cost benefit assessment for diverting part to an RO planet with off-site tankering. To which SEPA respond, that assessment seems to indicate that this option is not viable due to the cost of installing, etc. However, notwithstanding its non-viability, SEPA helpfully say this may be an option the operator wishes to investigate further. And the 2-year period is intended to give the appellant time to investigate and put in place technology kit, which will enable them to meet those limits. And then reservations about carbon filtration. And that all leads to the variation being issued. So I'm sorry to have gone through it at some length, but I thought it was helpful just to set out what is being, what is being contended. Now, there were 2 points which I suspect Mr. Martin can perhaps provide some further information or an observation. The first was the Grangemouth plant, which I think Mr. Martin has some information about.
More of a question. Yesterday you talked about other industries already had their BAT permits. Has Grangemouth got its new BAT permit?
The reporter is I would have
Calican,
to ask if
Grangemouth.
this is relevant to the discussion here.
I need to know whether it has a new permit yet, so I know whether I can take the residues to the site.
Sir, with my submission it is relevant because on any view, if the appeal fails, it's going to have to be tankered somewhere, and if Grangemouth isn't available, where does it go? And SEPA may say, well, that's your problem, Mr. Appellant, but with respect, I think that's a bit too simplistic.
I mean, the point I was going to make just now in response to the general narration and taking through of those letters is it's useful to be reminded of the correspondence there, and the question that's in my mind, and there's obviously quite a lot of things to potentially unpack in all of that. The question that was in my mind really relating to the kind of the SEPA response generally to these issues of alternatives and questions about feasibility of Grangemouth is perhaps tied in and rolled up in all of that, is that SEPA's approach in relation to the Table 13 is to say that a period of 2 years is being suggested to take whatever steps the appellants think are appropriate to do that. And as we've heard, there's correspondence on a whole range of various possibilities: reverse osmosis and carbon filtration, improved approach to reed beds and the like. The thing that was kind of troubling me a little bit about the SEPA approach was to say, you know, we'll continue to have a dialogue with you as to which of those we think might achieve the particular ends. But in that dialogue, the question that was in my mind is, if the appellants hadn't taken the appeal or were to abandon the appeal at this stage, and that dialogue was to continue, what would happen if agreement couldn't be reached as to something that might be an appropriate way forward? We have already, just because of the timings of the appeal process, we've ended up using a bit of the period through till March 2027, and if 2 years is a reasonable period, it's now much less achievable period. And I suppose my question really in that respect is, if these are things that the appellants are proposing and fall to be considered, have they all been rejected by SEPA? It's not for you to come up with solutions, but whether the SEPA position is that none of these are feasible, or whether the SEPA position is that some of them might well be feasible, and can we carry on talking, please, to make an assessment, and that might allow us to either give you more time or to work out a kind of an agreed strategy towards the meeting of EQS standards. And where does that leave, in effect, this appeal in those circumstances? So it's just really being clear as to what the SEPA position actually is. Have all these suggestions been rejected? And just say it's up to the appellants, or if it's still something that is can be developed and considered in future, the question then is, what does that do for the ticking clock moving to March next year?
So as Ms Crawford has outlined through the lengthy correspondence, there's been various options that have been discussed and which SEPA have responded to at all stages, and some of those, for example, the carbon filtration, it was the appellant that indicated to us that that wouldn't be able to treat the discharge to those limits. So we take their position that that wouldn't be an option to take forward. We don't assess those options that they're looking for as such, because we don't specify that treatment technology in the permit. And as you'll see by point of comparison, if you look at Schedule 13 of the permit, which covers the incinerator bottom ash and has leachate that comes from that, for which they treat through the RO process, we don't specify that in the permit either. The appellant's chosen to use that treatment technology there for the incinerator bottom ash leachate. And it's also reflective of the position under BAT and the BAT conclusions. We have in the BAT conclusions, you'll see there's a lengthy table that goes through different treatment options, and RO is a physical chemical treatment option covered by. But BAT is very clear as well that that is not exhaustive. Operators are free to look at other alternatives as well. So it's very much, we were in that dialogue, but it got to the stage that, you know, there'd been this lengthy correspondence over a year, that we really needed to put these limits in to draw a line under that and move forward. We felt it was being very reasonable given that 2-year period. We would probably have been in an earlier point of appeal if we'd put the limits applying immediately, but we gave that 2 years period, recognising that there was still that ongoing consideration by the appellant of their own operations and what treatment would be appropriate to meet those limits. But ultimately, it's not for us to reach agreement with them on that. We would look to, once those limits come in, that they have to comply with them, and if in their own deliberations about what treatment option to use, that it was likely that the one that they are going for in the end would take longer, we would expect them to come to us with that and seek a variation to that condition, perhaps putting that time, giving them a bit longer if they needed that, if they were like getting close to the end of that 2-year period. But it's not something that we don't specify in the permit, and we don't agree it with them. It's their choice what treatment technology they're putting in.
I understand that, but I can see that it's not a matter of something you kind of agree, because at the end of the day, there's lots of factors that the appellant would have to take into account, not least of which is cost, of course, which is the very significant part of that first letter that was submitted. But what I'm just thinking about are the kind of the financial and other implications from the appellant's perspective of how they would potentially go about these measures. I mean, it did and does appear as if the most likely way in which they could achieve those results would be the one that involves the cost that's identified in the first IESA letter. Now it's kind of joined together with other issues about the carbon implications. But I suppose my question in this is the extent to which requiring the appellants to undertake that level of cost and that level of implication for the operation of their business, if that is disproportionate and excessive as to what's necessary to achieve the relevant standards. The question really is to what extent. We may be drifting on to one of the questions later in the agenda. I'm happy to discuss that at any time. Whether that's a factor that I should take into account, and that whether it might be the case that by the appellants find that they spend this very significant amount of money in doing so, only to find that maybe it wasn't necessary to have done so, that there were other means by which they could achieve that result. Now, you may say that's for them, not for you, but it does seem to be that's inherent in the framework of all of this, of looking at the idea of its best available techniques, not including excessive cost, not entailing excessive cost, or whatever
So the not entailing excessive cost, and as we've set out in the framework of how we apply this, that's where it comes into derogation territory again. And that we're not in derogation territory, and it's perhaps useful if I ask Andy to explain the guidance that we were on earlier that we didn't actually get to explain, and just where you would be looking at derogation territory in terms of discharges to the water environment, because it's very different, and it's perhaps even more restrictive than the derogation territory we'd be looking at if we were under that conclusions. But both of them look at disproportionate costs, but there's that weighing up, and there's that looking at the environmental benefits as well. So that whole calculation that has to be done around that. But as I said, when we were talking about VAT yesterday as well, in terms of the VAT derogation test, we look at the environmental quality standards, and it's unlikely that you would get through that. I'll just ask Andy just to perhaps, or
I'm going to suggest we take a break just now, actually, because
yeah.
I'm feeling I need a cup of tea versus anything else. I don't know if around just short of 15 minutes is fine. We come back at 12 o'clock. If that's agreeable, and then we can maybe go into this. So I would quite like to understand if the same position is that this question of the proportionality and the question of best available techniques not entailing excessive cost is only in relation to the derogation, and your position is derogation isn't applicable. I'd like to understand that and hear from the appellants on that representation. Okay, so thank you. We'll just reconvene just now. Although we broke, I think, before for coffee there, on the basis that we'd go back and have Mr. Henry talk about derogation, I was actually thinking, in fact, Council, the appellants had said a similar thing in a different way. I was actually thinking that the question about whether we look at derogations probably actually starts drifting into, I suspect is going to drift into the wider question of proportionality, which is I think a little bit further down the agenda in terms of legal submissions. I was actually realising, although Mr. Martin was giving me information that included asking questions, I'd still quite like to get kind of a sense from him a little bit more about our understanding, for example, of what reverse osmosis actually is and what it means. That was explained to me a bit on the site visit, but I'm conscious site visit was in October and was quite a long time ago. I understand what osmosis means, I understand what reverse means, but it might be quite useful to get a bit of understanding, a better understanding from that, but also just anything more he wants to say about the kind of the operation on the site, because one of the things I may end up in a position where I'm having to reach views essentially on the correspondence that Aisha have had with SEPA and not much more, and that leaves me with a little bit of a kind of question of how fully informed I can be as to what the site, how the site actually operates. So if you could say a bit about how the site operates, about reverse osmosis, and if that comes into then discussion about how the other alternatives might work or might partially work to move towards meeting the Table 13 requirements. Now that will play into what we hear on the 4th of March, but I'm quite keen to understand how all of these things in different ways contribute to greater or lesser extents towards an improvement of the situation on site, and that I think would help me frame my understanding before we go on to these other wider issues. So it's a quite wide range for you to say. I should think fit, but we'll close you down if you're talking for too long. But feel free to explain in your own words, as they say, what the how the site operates and how these various proposals might work.
I'll give it a go. So today we have a biological treatment plant. That plant takes leachate from the Greengairs landfill site and from a number of other sites in the region, plus it takes RO concentrate from our sites in Aberdeen. Right. So a biological treatment plant works on a bacterial population, ones that you find naturally, they're in the soil, they're in the mud in the stream nearby, which eat the majority of the pollution we're concerned about, which is the ammonia and the organics. And what you do is you create an environment they're happy to live in, which is the ponds or lagoons, as I'd prefer to call them, and you adjust the conditions to allow the different bit of organisms to work. So you have microorganisms and your bacteria, and then you have larger ones which feed on them. So that's your amoeba and your ciliates. So these are little squiggly things you see on David Attenborough. And you have larger ones, you have things like dragonflies will lead upon them too. So you have a little ecosystem. That does the majority of the treatment. There will always be the bugs, the biomass, the bacteria will grow. There is always a need to, in effect, harvest some. So these are the solids you get generated. And they are removed by settlement in the lagoon. You basically stop mixing and letting the bugs settle out, and then periodically remove them. Or they're captured, because you can't always filter, things don't always settle, you capture by filtering in the reed bed. So the reed bed itself is another biological system where you have bacteria living on the roots of the reeds, eating away the various things you send them. And then that final effluent is then discharged via what's called a V-notch, so it's measured into the stream. Right. As a process, it's not designed to remove metals, and there's comment made that near the metal removal is poor. Some metal removal does occur because it's absorbed onto the biomass and it's captured in the solids. But predominantly it's about removing BOD and ammonia. Right. Predominantly it's about removing ammonia. BOD is less of an issue because most of the BOD has gone in the landfill site as landfill gas. Right. Now leachate itself is worth understanding that what we treat today is some leachate that may be, some liquid that may be generated from waste we've received today. It may also be from material that was received 10, 20 years ago. So as the waste breaks down in the landfill site, leachate is produced. As it rains, some of that will get into the landfill mass and will dilute that material, and that's what we remove. And we're required to have a maximum level of leachate in the site to protect the groundwater beneath the site. So that's about a head. Right? The other plants, the 3 local landfills, all produce very small amounts of leachate. Small amounts being 2,000 to 14,000 tonne, I think is the biggest one a year, compared to the 80,000 tonne which Greengairs produces. So Greengairs is the hub, and the other sites transport tanker material there. It's difficult to build a treatment plant to achieve surface water quality of small scale, so you wouldn't generally do that for small operations. Biological plants require feeding day in and day out. So again, if you've got a small landfill site which produces only little leachate, you can't use a biological plant because the bugs will starve. They don't like it. Right, so you'd go in this hub and spoke approach. The RO plant we operate in Aberdeen is for 2 landfill sites which are very old and are dominated by rainfall. So basically they have not got much leachate themselves, but it rains a lot in Aberdeen. So you have the potential where you have leachate production on and off. So you can't put a biological plant there. Historically, we tankered that material from both sites down into Greengairs. In 2015-16, we got a permit to run an RO plant up there to reduce that tankering, because it's a long way from Aberdeen to Edinburgh. Right, the savings in the transport, and again the carbon side of the transport, justified us doing an RO plant there. And the advantage for the RO for us is because it will, or is capable of being shut down when there's no leachate. If there's a sunny Scotland, as in 24, leachate production is down, that plant can turn off, it doesn't have any work, and there's no bugs to be saying, feed me. That's why you use an RO in that respect. Additionally, the discharge there is a small stream, so therefore you get the benefit of good quality material to be driven by both. So that's where we are today. We have our biological plant treating leachate from the adjoining side, plus imports from local sites where the tankering bit we believe is justified. We can't justify a treatment plant, and we're taking RO concentrate from Aberdeen. Well, we can justify an RO plant because the nature of the production there is up and down. There's not a lot else we can do, and we want to avoid having to tanker. So, end of chapter 1. Is that okay so far? Right. So, in moving now towards improving the discharge, where we've struggled during the process is whether we're talking about ecology or EQS criteria. To a great extent, it was for our bit dominated by ecology. The EQS numbers came out, what we required to achieve came out. There is only one technology which should achieve their numbers, which is RO. RO is a filtration technology whereby you're using pressure to filter down to molecules and atoms. So we can remove with RO down to things like, we'll remove all the metals, which are small atoms, right? We'll remove chlorides to a great extent, we'll remove the ammonia, etc. So it is a super efficient in terms of 99.99 type reduction in these components. Where you may come across RO in your wider life, if you like to go to South Africa or Namibia or Israel or Singapore, you'll find that the water production in them countries is seawater going through an RO unit, and the water you're drinking in the tap is the effluent or the production from that RO unit. That is a level of quality. If you're on a cruise liner, it's quite possible you've got water produced by an RO where they're taking it out of the sea, cleaned it, and you're taking that material. That effluent there is the equivalent to the effluent we would produce from an RO on leachate. There's some awkward bits about it. We have to do some control of how we operate the plant. The chemistry says RO will not remove gases. Ammonia is a gas, it can be dissolved in water, and depending upon the pH it's more gas or more ions. So we have to reduce the pH, keep the gas in solution as an ion so we can remove it.
Is that what you meant when you said earlier about the distinction between the water environment and the environment more generally? Is that the point about RO that can't remove things that are in gases?
So nothing is, no, the issue about the RO in that wider bit is in removing them components, we don't destroy them. They need to go somewhere else to be destroyed or diluted in a discharge, right? Removed in a discharge. But in doing that treatment, we're now into the situation where we are now using our energy to remove them components, and then we have a concentrate, the components we remove from site to go to a different disposal facility. Right? So in the biological plant, we've removed the ammonia predominantly because the bugs have eaten it. In an RO plant, all we're doing is moving the ammonia from 100% of the liquid to 30% of the liquid. So it's concentrated. As a liquid, yeah. So if you think of your diluted orange juice at home, we're doing the reverse, right? We're adding water, so we take it and then get back to stage one, right? So that's what we're about. So that's what an RO is about. So technology-wise, sadly, while I was waiting this morning, I googled AI and just checked, and yes, it's still there as the best technology, if you can trust Google AI. Right? So very efficient, right? It's there for removing stuff that's in solution, so you end up with a concentrate. It doesn't destroy the stuff in the solution, it makes it into a smaller volume, which then you need to deal with. That's the process. It will meet the criteria we're having to do, full stop. I'm not worried about that. We took the opportunity to check, because we've got a plant on site. Right? We have currently 6 other plants around the country, so it's not something that's new to us. I think though we're only operating in the UK using our own leachate today, but when BAT comes along there'll be a lot more. Right? But if you go into Europe, you'll find it's common. Right? Full stop on that one. If you wanted to try get near that quality, but not achieve the same quality, your alternative is to evaporate the leachate. And then you're in a different order of energy use. And reality is you will not achieve the same level of effluent quality. And if you wanted numbers on that and energy use on that, I can give it. Right? Throughout the last few years, and probably the last 10 years, BAT has been present. We've seen BAT coming along, we know it's coming. We've seen how Europeans are working, we've seen the rules are changing towards the European. So this is not new to us, this is stuff we've been looking at for years. You know, and so the first RO plant we built was 2016. Right? And one of the reasons you use RO is it's almost bulletproof regulation, as long as you can get rid of the concentrate. The effluent is the best quality you're going to get, but you need to be able to get rid of the concentrate. And I'll just go a slide here. That is a concern to me because at the moment we have the BAT regulations coming through. It's colour came at Greengairs that I'm talking about earlier on, sorry. Right. So the question comes, when the BAT arrives, will they still be able to treat that material? Because they are a biological plant. Right. And you have that scenario where you're chasing yourself into a corner if you're not careful. Right. You cannot destroy metals. You can remove them and landfill them. You can put them into a nuclear reactor and destroy them that way, or in effect you rely upon dilution at some point along the line, where the EQS allows that to happen, unfortunately. So, slight aside, the only comparative technology to RO is evaporation. It doesn't meet the same level of quality, right? And is even more energy intensive. I say if I get it right, 35 kilowatts per tonne, so that's 3 times as much. And that still only gets you to a concentrate. It doesn't actually get you to anything else. So there we go. So to meet the criteria, it's RO or fail. Full stop. In going back through all the correspondence over the years, the discussion was about ecology, And our concern has always been, we are worried about direct discharge at the point B. We can see from the data that after point B, the quality improves and then drops off again and then improves again, and then we have nuggy water, good chemical quality. So to an extent that has driven our thought processes. You know, we're now told, you know, and I understand it, it's point B and only point B that matters. Right? So in the thought process about it's okay, there's potential ecology issue here, notwithstanding that the biological plant has its own ecology, some of which is the same ecology that is in the streams and in the soils. Right? You know, it is a community that has to survive to actually do its job. Right? So, how can we improve our effluent quality without using RO and look at the ecological matters? Carbon filtration, and its change is very similar filtration, right, will remove some of the metals, but it will not achieve the level that's being required. As I've said yesterday, the level required for chrome is below the standard for drinking water. So it's tighter than the standard for drinking water. That's a tight standard. But is what is required to meet EQS at that point, not arguing that. Right? But that is what is required. Right? So it will achieve something, it will achieve some removal of BOD. So there will be an improvement, but it will not be an improvement to the extent required. If the discussion is around ecology, right, the issue we have, and this will be in March more, the stream we're discharging into, our unnamed tuberosity, is essentially a drainage channel for landfill. It's never going to support a good life. So potentially the argument is, well, could we improve upon that? But if the measure is EQS and not ecology, that's pointless, because it will not improve the EQS. In the discussions, and this is where the 500 and 350 metre cube comes from, ton a day come from, the permit allows 500. In practice, we're about 300. In the modelling will assume what the permit says. So by changing the volume, we can make the modelling easier, but it's not significant to get below the EQS. So that's why that came out into discussion. We don't need 500 tonnes. 500 tonnes is making the model harder to work, so reduce it more like reality. Does that make it any better? Marginally. Scottish Water sewage works in Watson is on the boundary to our site, so we talked to Scottish Water about whether we could actually send them treated effluent, and capacity wise they haven't got capacity for it. So that died. So even though we've treated it, right, the volume we discharge is too large for that sewage works. And that sewage works itself may be part of the problem further down Cameron Run anyway. So there's an element there saying what we're achieving by us moving the problem. So that one died. I had a longer conversation with Scottish Water about piping the material. I think it's about 10 kilometres to a new works they're looking at, but that's got nowhere. They don't believe they have capacity for it, so that's parked. So I'm stuck. Right. Currently, I have £1.6 million in this year's budget to build an RO plant, and depending on how long the process goes on, I may or may not achieve March. But I don't think it's the best environmental option for the amount of the area we're talking about. That's a personal opinion, right? At the end of the day, it's easy to say the law says do it, so we just do it, right? Longer term, the Greengairs landfill probably has 2 or 3 years life before it closes. It changes all the time, right? Because it's down to, is there a market for it? And obviously the Scottish landfill ban, which has now been delayed, I don't know when that's going to come back. Right, but once the site's closed, the leachate will still be being produced, and we have to look for 60 years of aftercare. In our modelling, we took 20 years, because bluntly the rules will have changed sometime between now and 20 years anyway. So, I think I covered everything.
On that last point, obviously, none of us can tell the future in terms of changes, landfill tax or otherwise, might impact on this. But is that question about the future uncertainty of this plant at this site is that a factor that comes into the question, if you like, the economic question, the financial question?
No,
that are thinking about
the
land
treatment
trusts?
plant is not uncertain because we still have to treat the leachate even though the landfill operation has stopped.
Right, okay.
That requirement can be up to 60 years.
So in other words, if the money had to be expended, it would have a long shelf life effectively. That's helpful to understand.
Or until the rules change again
Okay.
and technology moves on. Right, but currently, and I was saying it yesterday, currently I'm not frightened by BAT if I've got an RO unit.
Okay. Two other questions there. One of which is that you've been very plain and very clear that you say in looking at the obligations that are there, you're stuck. You don't know what to do that can achieve those standards. If you were in SEPA's shoes, looking at this at a plant of this nature, stepping above that, I'm stuck, which I can see you are. What's your solution? Do you have a solution? Is there anything you've gone through? A kind of useful explanation of reverse osmosis and the other options that have been looked at, but accept, I think, that those other options won't achieve the outcome. So if the outcome needs to be achieved, how can this be done?
Only by doing the RO option. There is no other option other than the RO. That's it. Oh, sorry, and tankering the material away. Assuming the site we tanker to is actually able to take it, depending on how they get through the MAP process.
I can say a little bit more about the experience of the company more widely. I think you said there are places where FCC operate in Europe, and I think that was what was said on the site visit as well. There were some examples. I think Spain was mentioned, the various other operation places.
We do operate in Europe.
In various countries. So my question, I guess, is you've seen this coming, and RO has operated elsewhere. How have they addressed the carbon implications? Are there examples elsewhere where they have similar problems of having to transport the concentrate to a kind of Grangemouth equivalent? And can they manage that, or do they have the same concerns?
First, the application of EQSs across Europe are not consistent. Some people are better than others. Some people are ahead of others. So, in terms of our experience is only in Spain. The experience I talk about is my suppliers tend to be German or French or Spanish companies or Americans. So I look at what they've been doing. So I had a lucky jolly in Paris in August last year, where I went to two landfill sites operated, one by Veolia and one by a small operator. The Veolia site, which is a big one near Paris, is operating a treatment plant akin to what we have today at Greengairs, with an RO on the back end. They had an operation whereby they would also take the RO concentrate and evaporate that down. That was causing them problems, so they stopped doing that. They tankered material away to an industrial waste treatment plant like the Calochem at Greengairs. So that is, you can't get away from that, all you've done is minimised it. Where we have some differences in France, you cannot discharge treated leachate to a sewage works, it has to go to surface water. Right, so they have different rules there. The EQS standards used in France are variable and will vary throughout the year. So in summer, an RO plant is less efficient than winter, so they've actually allowed a wider and more relaxed ammonia discharge. Right, so there's fluctuation variations like that. Right. Some of the components we've seen now coming through with BAT and some of the changes coming along have been in French and German law for years. So 2016 was the requirement to meet some of the BAT criteria in France, and some of the BAT stuff is written on French's law. Right. In this country, we were consulted on BAT in 2015-16. This is we, the waste industry, EA. I'm not sure SEPA turned up. Right. I can't remember, NRW were there. At the time, the interpretation of BAT was we'd still be able to carry on with a risk-assessed approach. And what's happened over time is that that's actually disappeared, and we're now into this type of scenario we have today, which is the rules are this, you do it. Right, so there's been a nuance change there. and as time's gone by, as I alluded to on the net zero side of things, carbon, climate change has come through, and VAT itself and BREF and EQSs predate that discussion. So there's things we can learn, right? Sorry, expression. They solve the problems. There is definitely an advantage in Europe, is that there is a lot more money involved in dealing with landfills than is in the UK. So they are much more profitable when they are operating concerns, but that's irrelevant, right? So it's a different beast in that respect. But there's certainly flexibility between countries, and there's flexibility within regions within countries about how they interpret the rules, which isn't what we want to hear, and that just makes things confusing, but that is the reality. Is that enough on Europe? Do you want to start talking about America? We can carry on. I'm a techie, I enjoy toys, and yeah, I'd be quite happy for FCC to buy me an Arrow, right? I like them, right? But in this scenario, it feels wrong, but that is because my bias, my thinking's on the lines of, this is a small part of a small water body, which then improves and then goes the other way for other emissions discharges, some of which are man-made, some of which are semi-man-made, such as road runoff. You can't stop road runoff today, right? Some of which may be to do with the mine water, it's a mining area, it's a peat bog area, etc. Right? All of them contribute that. So for me, there'll be areas along that Cameron Burn which will fail EQS through no fault of man, and then improves and then fail. So my issue has always been around at point B, is that water quality there worth this amount of expenditure and effort? And currently I'm on the argument of no, even though I like the toy. And I get to choose the colour too.
In my mind, I think I will tell you over Stephen just now. I know I'd like to ask you questions about comparable sites within Scotland and just examples of that in more detail. I've asked you about a wider European example to see if there's anything that can be drawn about equivalent agents. But I think we'll come back to that later, and we'll maybe kind of go over to SEPA to see if they want to bring in, have any questions that arise from that over above mine, on whether there's anything else that anybody wants to say on that side. And I find that very useful, because a bit of the RO process was explained to me on site, but it was a number of months ago, so that was a useful reminder to me. Thank you.
Thank you, sir. Certainly that was a very useful description, and particularly around the European position, but I would have to disagree with some of the points put forward in terms of the European position, and certainly the suggestion that at the time of development of the back conclusions for waste treatment activities in 2015 that there was still discussion around a risk assessment process being used. Back conclusions were well developed by then, by the time the waste treatment ones were coming in. These have been developed on a European level. There is a set process that's set out in Article 13 of the Industrial Emissions Directive about that process, which all member states feed into. There's technical working groups that gets discussed, and they seek to get the involvement of industry. So looking at specific sites from the UK would have fed into that process, even though it was getting very near Brexit. And in that process, they look at differences between countries. So if there is a particular geographical situation for Spain or something where they have a different issue, that's where you get the development of the multiple, very confusing to read footnotes within the back conclusions, trying to reflect these different scenarios. And it's also where the derogation process comes in again, reflecting that there might be different scenarios on a member state level.
Is that in 1147? I'm talking EU decision 1147.
So the EU decision is the actual back conclusions once they are adopted by the European Commission. But prior to that, there's a long process that goes through the Joint Research Council. It's referred to genetically as the Sevilla process because all the meetings happen in Seville. And that's where all the technical experts, all the member states, different regulators, and everyone comes together in a lengthy process about looking at the specific technologies, looking at the different plant, bringing all that knowledge and experience, and then in developing what is ultimately then put. So they have BREF documents that are the BAT reference documents, and that really brings together all that exchange of views that's feeding into that process. The BREF will then have the BAT conclusions within it, and it's then the Commission that adopts those BAT conclusions that are published in that decision document that we've got there.
Does the UK still have a seat at those discussions in Seville?
No, the UK now has a separate process, UK BAT process, that they are looking to develop their own. So I think in terms of looking at saying about, I think the example you gave was France has different standards. You know, they should all be looking to achieve the same standard, and obviously that's where the Commission, as oversight of implementation of the Industrial Emissions Directive and all of the BAT conclusions that come under that, that is where the national regulators in each of those countries will be seeking to ensure compliance with those BAT conclusions. So if there is differences between member states and that flexibility that Mr. Martin referred to, that is an enforcement issue, a compliance issue at the member state level.
Control of the truth. That's what it is. Should is a key word.
Should be, yeah. So it's a classic view, often in the UK, that others don't comply with the rules and we do, kind of idea. But that's been an eternal problem with the operation by the European Commission, I guess.
But the Europeans also saying the same about us. So the stuff that we do, the Europeans wouldn't do. So, the 2015 was a working group set up in the UK. I think it was the UK, certainly Wales were involved, where the EA, who would lead on BAT, right, called us together and we went through what the conclusions meant and how they'd be implemented and what we should worry about. So we fed into that process, and the discussion then was around there was a degree of interpretation in the footnotes which would allow some risk assessment approach. So that was then moved on, that's fine, but that was a discussion at the time. It is a bone of contention we have with EA today, which will come out again and again over BAT. Right. It's also, just to go back a stage, the BAT process in terms of the emission limits come from collection of data across Europe, but it's not specific to leachate. It's specific to water-based waste with some exclusions, and one of the problems you get in this scenario is we have a generic set of tables for water-based waste as opposed to leachate from Scotland, leachate from England, concentrate, pick another waste stream, right? So it is an issue there, but we're not talking about BAT, we're talking about EQS.
I think perhaps the point to take from all of this discussion around BAT is that we're going back to BAT, but we're not applying BAT here. So it's all very interesting discussion and going into the history of how they've been developed, but clearly the awareness of the operator about the BAT conclusions, the development of them, shows that, you know, they've known that this is coming for some time, and as we said yesterday, there are still other elements of those BAT conclusions that we will have to review the permit against, which will require, it sounds like RO is the only option for meeting those limits as well. So
To have an advantage of using derogation argument.
But we'll come to that. We'll come to that just in a second. But I wonder if you want to, were you able to say a little bit more just about the extent of those costs? I mean, the letter which Council has narrated and sets out, even disregarding the adverse carbon implications, sets out in quite a lot of detail costs, both in terms of capital costs and ongoing annual costs, and significant figures there.
Yeah.
I mean, these are no small numbers. I'm not necessarily seeking information about FCC as an organisation broadly to get a sense of how big the company is and how £25 million is it a lot of money to them? It's a lot of money to me, but is it necessarily a lot of money to them? If you want to say something about that, then that would be useful. But if you could maybe, I know you don't want to be flippant about amounts of money. I'm also interested actually as to whether part of the concern from the appellants is not just the implications at this site, but whether the concerns is if it's going to cost you whatever amount of money here, does that have a set precedence effectively for other FCC plants or plants operated by others elsewhere in the UK and beyond? So if you could say a little bit, there's a number of topics there, but if there's anything you want to...
Take the last question first.
Of course.
It doesn't set a precedent because, again, the rules are the rules, and the rules are applied on each individual site, right? So I'm not concerned about a precedent bit. In terms of the costs, we operate plants, we've built plants, and the last build we did was in 2024, right? So that's our latest plant, which is in Lancashire, right? So we know what footprint we require for concrete, we know what tanks we require, we know what the plant costs. I can give you 3 suppliers, I got 3 quotes, right? We know what it costs to operate because we've operated them. We also have the specification from the supplier. So in terms of the kilowatt hours per metre cubed, we know what it's going to be. We have a rough idea what the maintenance costs are going to be because things break. So the financial side, we're pretty comfortable, we know what it's going to cost us, right? From the time we did them costing, which was 23, 24, we're now in 26, so there'll be some inflation, right? Generally we're buying from Europe, so the euro-pound rate matters. Right? The reason we buy from Europe is because the Europeans have been using the technology for a while, and in the UK we're not very good there. But ultimately, RO is made up of some intellectual property, the people who designed the program, and it's a bunch of pumps and pipes, which you can buy from multiple places. But you put it all into one unit and a control system. Right, so that side we're comfortable with. Right, we sit in a box. We've done a rough idea how we can fit it into the site around the existing bit. There's a question about whether we need planning permission for it or whether we can, in effect, count it as part of an existing development. So that will come in time. Right. Concrete, if we were going to do the concrete, obviously we're going to do it in the summer. There is a waiting time to buy the plant, right, as is always, and depending on who else is around, who else is waiting. So cost-wise, availability-wise, we understand where we are. Right. We have used the technology before for situations where we either want to save on haulage costs, so the idea of mention of Aberdeen, right, or we have to meet a high quality effluent requirement because it is an important stream. And there's a high quality requirement, and it is the only option. Or the leachate is so horrible, the bugs don't like it, and we can't use a biological plant. Yeah, right. The biggest concern around RO is disposal of the concentrate. Now we've reduced all the awkward stuff into the 30%. That needs to go somewhere. And that's where the costs come, right? And we've based it around Calochem, and our concern, and the reason we've gone the way we've gone, is are we going to be sure we can dispose of that material?
And presumably, although it is a non-hazardous site generally, by the time it's concentrated,
it's still non-hazardous. It still falls below the thresholds.
Okay.
Yeah. So you're talking about concentrating low numbers by threefold. So they're still low numbers. Yeah. Right. Where the concern is we need to dispose that material. Right. That is coming in. Right. There's not many options in Scotland. Right. There's other regulatory requirements coming on, other concerns coming on, so there's always a concern around that. So in the ideal world, you'd rather not produce concentrate. The English scenario is very similar. We can see this coming along, and in essential we'll end up building our own plant to dispose of the concentrate. That'll be difficult for the volumes up here.
So it's going to go over it again. Why there's a particular problem or disadvantage in increasing concentration?
So we need a disposal site for it, some of the industrial capacity to take it. Right. They are also going through regulatory change at the moment, including BAT. Right. BAT provisions may impact upon their ability to receive our material. And that's foreseeable around the metals concentration, and you'll understand around debate and imbalance sugar treatment. So we're reliant upon a third party or another operation to take that material. Right. We talk about Calachem. Calachem's on Grangemouth. Grangemouth is going through its own changes as well as the regulatory bit, so there's a concern there. The second alternative is it Shield Hall? Get the name right? The Scottish Water site in Glasgow. Shield Hall is a second option, but again, with the issues around BAT, I cannot be sure that's actually going to be present, because again, we are moving a material which we've considered metals. So while they're not hazardous, there may be an issue to receiving facility due to their regulatory concerns. There's a lot of change at the moment, so it's very difficult to actually plan. And as I said earlier, if I wanted to, I could take that concentrate and dry it by evaporation down to, if I was to evaporate it and use a crystallizer, I could make crystals. Then I need to dispose of them crystals somewhere, but that's a lot of energy. Salt.
Concentration again.
Yes. You know, in the day, if you run your kettle long enough, you'll end up with the scale left behind. I can do the same with leachate, but it's not advised.
Why is it not advised?
Because you end up then with a salty material and you need a landfill for it. So you're going to take a salt material in a landfill site, and as soon as it rains, that salt is going to get dissolved and be in their leachate. So it goes around the cycle again. Yes. And no one wants to incinerate salt. And when you do incinerate salt, you still end up with an ash. So you end up in, say you paint yourself into a corner.
Can I perhaps just...
Absolutely. I don't think there's anything else you want to say. I mean, I'm
fine.
quite keen to get your response, but also more generally, looking at the question of what's been said there about costings and that technical evidence. I mean, what's a clear indication there about the disadvantages of what would require to be done, the costs of what would require to be done, the uncertainties that arise from all of that. So I've kind of noted that, and I think I understand that. So I suppose really the question is whether you've any sort of responses to that. What I'm thinking about is in terms of how I now take the evidence from today particularly, and then assess that in terms of the documentary evidence of in trying to kind of find a way for me to go forward on all of this. But certainly if you have any responses or any of your witnesses have responses that would
there's a
help.
number of points that we would wish to come back on, and perhaps if I deal with the last point first, looking at the concentrate that comes from the RO process. So at the moment, as Mr. Martin has highlighted, and I'll ask Stephen just to come in and say, the concentrate that is being produced at the other sites of the appellants is being tankered, but it's not being tankered to a treatment for discharge at another site. It's been tankered into the Greengairs site and being brought in at the head of the works. So it's then going through the leachate treatment process. I'll just ask Stephen to come in on that.
Yeah, and again, these are all kind of commercial decisions that are for the operator to make, and go back to that point, it's not for SEPA to stipulate how they achieve their permit requirements. As Mr. Martin's touched on, that there's 4 sites that the FCC tankered their leachate to. Greengairs as a hub site, as we talked about at the site visit. I believe there's 2 in Aberdeenshire and 2 in Midlothian are the ones that we can see in the waste data returns. So again, and that kind of, and not to go back to whoever we were earlier on about the carbon counting and things like that. That's where we were slightly, I suppose, concerned, and it was quite a narrow focus on the carbon of the leachate concentrate going from Greengairs to Grangemouth, but not really taking the whole situation in terms of what implications that might mean for the leachate that's been tankered to Greengairs for further treatment. So again, looking at that side of it, that's maybe something we felt was lacking in that FCC document 8. And I suppose just touching one more point around about reverse osmosis, you know, there's 6 plants we believe that FCC operate, which would suggest that this technology is economically viable and technically feasible to achieve what we needed to achieve at Greengairs.
Thank you, Stephen. Yeah, just to make the point as well that because this concentrate is being brought in from these other 4 sites and it's going in at the head of the works, it's effectively being treated through this treatment process that we are now dealing with the leachate from. So that concentrated element is going in and going through that subsequent treatment at Greengairs.
The current concentrate comes from sites which are very dilute because they're dominated by rainwater. That's why it's narrow. So you wouldn't recognise it as a concentrate if you looked at it. So it's much weaker than what would be produced from the Greengairs plant. That's where the issue comes.
But yeah, it's just to make the point that it's going in at the head of the works, and it's part of then what is going through and being discharged as part of the leachate treatment here.
So is that a process of concentration at the other sites as well, or is it brought unconcentrated and then is concentrated at Greengairs?
Mixture. The material coming from Aberdeen is a concentrated leachate with no initial biological treatment. So it has the ammonia, has the bod, has the trace metals. So it comes in as in effect as a leachate. The biological treatment plant removes the ammonia and the BOD as it would if it was a leachate. Right. Greengairs scenario is different in that we've done the biological treatment and we're now polishing the effluent from that biological treatment. So all the concentrations of the ammonia and the BOD are much lower to begin with because they've already gone. They've been destroyed, eaten by the bugs. So it's a different scenario.
A different scenario from Aberdeen.
The other sites are pure leachate. Are pure leachate. There's no concentration. But because and this is this discussion about the quantities are small, too small to justify doing a treatment plant. You know, if you've got 15 tonnes a day of leachate, it's difficult to justify a treatment plant, which is a situation you may have in these sites.
And that's part of the economies of scale. That's the reason why.
It's economies of scale.
The business operates in this model.
There are also closed landfill sites, so if you then want to do a treatment operation, that's a planning issue. And if you've already decided that your closed landfill site is now going to be a dog walking area, etc., trying to put in what is an industrial facility, even though it's in a box, and get permission for that can be problematic. Yeah. You know, you've closed the landfill site, you've gone now. Why do you want to come back? Type of scenario.
Yeah, it was just to make the point that when we're talking about this leachate treatment for Greengairs, we're talking about there's not discharge limits at these other sites that they're having to meet. This is coming here, and this is the one point that we've got the discharge to the water environment for that leachate that's coming from multiple sites.
Aberdeen has a discharge point because we didn't it there, but yeah.
If I could just pick up on a few other points as well. Just trying to, from what you were saying earlier, Mr. Martin, about the discharge, and again the point that we assess it, and I think you referred to then breach of EQSs at various points down the unnamed tributary of Cameron Burn and beyond through no fault of mine. But again, it's this discharge is the point that we have to assess it at, and so it was just the reference to right. Okay, thank you. If I go on to the costs point, I think that that you would particularly like me to address. So I think the appellants claim that SEPA has failed to address proportionality, the question of costs in our correspondence. But again, as we've set out in, I think that was in the appellant's document 8, which is the letter from AISA to SEPA dated 23rd of April 2024, that sets out, as we've been through in detail today, the costs of the reverse osmosis process. We can't agree or disagree with those figures presented, and it's not for us to do an assessment of that. We recognise the appellant is best placed to do that. They have the experience, and as we've heard, they operate reverse osmosis on a number of their sites. Only to say that certainly from when we were on the site visit, and comments made during the site visit was certainly that, you know, this is now the technology that is used by everyone, and that the costs of this are coming down. I think the unit that we stood inside had been bought second hand from Germany, and so it was just to say that obviously as technology moves on, costs change as well, but they'll be best placed to know what the current costs are for this.
I mean, I'd be interested, Mr. Martin, whether that, if he accepts that, I accept at a general level, as technology develops in lots of areas, laptops have got cheaper over the years and various things. I would welcome your views on the extent to which that, insofar as you can tell the future, that is likely to be the case, or do you dispute that suggestion, or it may happen but may not be material?
Today, I would say that prices have come down. There's more competition. You know, we've given you quotes we had, so that's, you know, a genuine quote. I have other quotes, right? I see going forward potentially going the other way, because you're right, technology is getting cheaper, but there's more. We're going to worldwide issues now about, can you get a chip from America or China or Taiwan, and all these other issues about availability of the actual equipment, right? Also, with the movement of BAT, there's an issue now potentially around how too many people are going to want the technology at once, so the waiting list. So I think there is a short term, yes, prices have come down, there's been more competition, people have squeaked, right? Longer term, I'm not so sure, right? But that's true of buying cars and most things.
Yeah, so. I'm wondering, is this one of these rare minerals things where there's a wider concern, not from this hearing, as to the extent to which reliance on certain countries that have these?
Yeah, our road plants are not clockwork, unfortunately.
The most that could be said is the future is uncertain. Probably.
But I mean, SEPA's position is that you know, we don't take that cost into account in this decision. We've applied the environment, the standards which we're required to do. There is this. We've perhaps jumped on because I think we're on item 4.3 and we've missed out 4.2. But
using it all mixing together for a certain extent, we are beginning to move on to that.
Yeah.
And it may well be that we wouldn't.
But from a sort of more general cost perspective, you know, RO is recognised as a treatment technique. This is not something novel that we're looking at here. It's referred to in BAT conclusions, which have been developed across Europe on the sectoral level, which also takes account of the costs at the sector level. It may not take account of the costs at an individual site level, but this is a technology that is available and it's recognised as BAT. So we wouldn't in this individual decision making process, we wouldn't go beyond that in looking at the costs unless we were in the derogation territory, which is where I come back to this assessment of the disproportionate costs and showing that against the environmental benefits.
I'm conscious a little bit of time and trying to work out the scheduling of our next session. I think one of the issues from Council for the Appellants that and I think we'd actually like to hear later on about is that very point of the extent to which costs, the recognition that costs are part of the process is already factored in the setting of the BAT conclusions, and therefore to an extent regard being had to that already, but at the same time the framework does recognise, and it may be only on derogation, that it does recognise that in fact there's a possibility
Specific circumstances.
Getting specific circumstances, things. So it probably actually both comes into play. That it's already built in, but it's built in at the macro level with the understanding that there could be local site specific circumstances which could lead to a different conclusion.
Yes, I would agree with that, and I would also, it's more a point again for closing submissions and authorities, but certainly there's case law around that costs cannot be used as a reason not to meet statutory requirements if we have that. If you accept the basis of our decision making here and the clear duty that's placed on SEPA to place these limits on the permit, that doesn't take it. There's not an element of cost in there.
Okay.
Sir, I wonder if I might
see
just
that, but this time,
briefly come in. You were talking about BAT and costs being built into BAT. As we now know, we're not dealing with BAT. So I'm not sure to what use it might be me commenting upon whether that's correct or otherwise. I can, of course, address and will address in legal submission. I know there's going to be some discussion about proportionality and the extent to which SEPA can legally take into account costs in relation to, as they would have it, their requirement to operate under the EQS. But as I understand it, and I would welcome what I've already had clarified, we're not in BAT territory here.
I think I was more thinking of the analogy.
Oh, I see.
With that. Right, I think I accept that.
I see,
point.
sir.
The fact that the European level are aware of costs, but as part of their recognition of a general awareness of costs, there is this point about the fact that there could be exceptional site-specific circumstances, and this is very much the case that Mr. Martin is putting in terms of the overall, the pound, shillings and pence aspect of this.
If I
But
could just,
it is for representation.
if I could just clarify that last point made about Ms Crawford, that BAT doesn't apply. Just to clarify, when we've been talking in this, we've not done the BAT review against the waste treatment BAT conclusions, but BAT always applies. It is an ongoing obligation on an operator, and the technology we're talking about here is reflected in the BAT conclusions. It's recognised as BAT.
No, sorry, I was just meaning that, as I understand it, you're not using BAT to justify the limits, was what? Yes.
Okay, right. We're nearly at 1 o'clock, so I was going to suggest that we take a lunch break just now. I'd like to give legal agents some time to reflect and think about what they want to say to me today on this thorny issue of proportionality and how that interacts with the obligations. But in terms of reviewing the afternoon just more generally, I've got two things in my mind, particularly in terms of the evidence from people who are here now that could be useful to bring out to assist me. One of which is to ask Mr. Martin. I deliberately didn't stop you earlier on because it's set as a separate topic, is the interaction with the other permits that you've drawn. I'd like to hear you separately talk about that. I thought that would be useful, not least because it's not part of the agenda. And the other aspect then is Mr. Hemingway talking about the kind of the context of whether this is a derogation or not. So they're the two other pieces of factual information that might be useful to deal with when I first come back. I'm probably inclined to go to Mr. Martin first after lunch, then go to Mr. Hemingway, and then we can decide then what we do by way of what needs to be said today, by way of legal representation, and then decide next steps. So one of the next steps we'll have to think about is just a little bit further thought as to the nature of the hearing when we reconvene, and we can do that before we close today. So I'll break on the dot of 1 o'clock, 1 o'clock in 2 seconds, for 1 hour. So return here at 2 p.m. Thank you. Okay, that's 2 o'clock now, so we'll just, I think, reconvene. And I think I was going to start with Mr. Martin, who's going to talk to us about Granish and Bin Farm, I think.
Talk or query, I think.
Oh, query's fine.
Okay, so item 14 and page 28 in that document. And table 10 is what we're looking at?
Is this page 28 of the actual document?
Yes,
Okay, that's it, yeah.
table 10. So these are standards for a large village treatment plant operated by Highland Council Inverness. And we talked yesterday about EQSs, and that is a standard. EQS is a standard in the receiving water across the country, with some variations about saline water, etc. So here we have limits for chromium nickel of 0.5 milligrams each. And I'm curious, is the background water very poor, or is the flow very poor to have such high numbers compared to what we're having to achieve? I believe this is actually discharged to groundwater via soakaway, and groundwater is one of these surface waters we are talking about, I think, or water courses we're talking about. So I don't know the background, I don't know the modelling, I'll just look at the numbers saying they look strange compared to where we've ended up. And then I have a similar point for Sewers Bin Farm, so that's item 15, and it's page 20, which has a much smaller list, so another table 10. Has a much smaller list of contaminants they're having to monitor, and actually doesn't have any numbers for chromium or nickel. So either they're not present, which is unlikely given its leachate, or they're not significant in the receiving water in the EQS approach, or there's a different EQS approach. So just where we've ended up seems very out of kilter with these. Now, both are in the new standard format for the permits, but both will have to go through the BAT process, and presumably when the BAT process comes, they will be in a position where they will have very much tighter discharge limits, or they'll go through the derogation process and argue why they don't need them. Because the BAT says this is the minimum standard, and the agency, SEPA, can only make them tighter if the EQS requires it. So these two sides have a problem coming, but at least they have the benefit of derogation approach. So commentary rather than I don't know the answers.
Yeah, so I can speak to those sites. I suppose I'll make a general point to start with, and then focus in on the two sites that have been mentioned. So when we come to set limits, obviously we take the same approach, but there's obviously site specific context that needs to be applied, and the capacity of the receiving waters is also a factor when we're setting limits, and some of the things we've talked about dilution and things like that, which obviously Greengairs really discharge into. There is very little dilution. When we speak about Greenish, there's that fundamental difference is that it discharges to groundwater. As we touched on via soakaway, it doesn't discharge like leachate through a pipe or through a ditch to the water course. So it'll be, as I understand it, will be the groundwater directive standards that will apply when we're setting limits for those for that discharge. And the discharge there is, as you say, it's via soakaway. It's at 1.4 litres per second, and the similarities with Greengairs is that it's an operational non-hazardous landfill site. It was reviewed as part of the sector review that we've talked about, but as I say, there's that very fundamental difference that it discharges to land via soakaway rather than discharging to a surface water. In terms of the second site that was mentioned, Bin, bin farm landfill. That's a closed, non-hazardous landfill site. That wasn't reviewed as part of the sector review. The permit was reviewed as part of the closure process. So there was a slightly different process that we went through. But again, I'll go back to the process for setting the limits. It will always be through the Monte Carlo mass balance model, and it will be based on the capacity of the receiving waters. At that site, we understand that there's undercell drainage that discharges to lagoons and thereafter to a burn, so that one does discharge to surface water. So that's where we would sit with those two sites.
And presumably they'll be given a back review because of leachate treatment operations, and then what will happen?
Until that review is carried out, then I wouldn't be wise.
How would you imagine the review would be carried out?
Yeah.
This leachate treatment plant back applies, therefore need to meet the back requirements, and if they go down the back requirements, they have the opportunity to go the derogation route. True? Sorry.
I think if I can again just ask about the relevance of the question there, because we're dealing with the consistency and approach here, and in terms of these two permits have been highlighted to us, but what we're seeing is this is very much a consistent approach in how we've applied the EQS and given the different site specific characteristics.
I have one question about the difference, and just maybe Stephen can explain this a bit more about the difference between a discharge to a soakaway as opposed to discharge to a surface water. I think that was the point you made on the first of the two examples that were given, and just ask why that's significant.
Yeah, it's significant in the sense that the treated leachate will discharge to land via a soakaway and into the groundwater. So it's the groundwater standards and the directive that will drive the limits rather than it being the EQS that we used for Greengairs that'll drive the limits for Greengairs.
Yeah, I understand there's different standards. I'm just wondering if anything you can say to explain why the standards are different, or is the context of how they come about different?
Yeah, that essentially comes back to where the standards are derived from. So under the Water Framework Directive, we've got, I think as I've set out in my submission, we've got the two daughter directives. So separately we've got the Groundwater Directive, and separately we've got the EQS Directive.
Between whether the approach taken, mindful of circumstances, arises in the context of a derogation. I think there's a number of aspects of this that need to get drawn out, and I think Andrew is going to speak to us about that.
Well, I can just explain why what SG 68, which is document FCC 7, doesn't apply in this case, and it's a supporting guidance for two car documents. There's two car documents that are relevant, what RM41 and what RM34. And looking at RM41, that only applies for controlled activities causing a downgrade of a water body, and where the operator's arguing that they don't need to take the action to improve the status of that water body. So in this case, RM41 doesn't apply because our situation doesn't relate to a downgrade of a water body, because the Luggy water body isn't downgraded. That's the water body that's about 5 kilometres downstream. So that there's no downgrade of a water body, therefore so RM41 doesn't. It means it's downgraded from good water quality status as defined under the WFD.
The Water Framework Directive classification, the Water Framework Directive classification status
has been downgraded.
Yeah, and the Luggy water isn't downgraded. Yeah.
So why does that allow for derogation? What are the circumstances which RM41 would apply? So you have a downgrading of the water course under the Water Framework Directive.
The water body, yeah.
The water body.
Yeah. And
so what does that mean in practical terms for a person who's affected by this?
Well, we would normally require the action taken to improve the status of that water body to good status.
To bring it back to the status from
Yeah.
which it was downgraded.
Yeah.
Yes. Okay.
And that's what our document RM41 talks about. But that's only in relation to water body downgrades, and this isn't a downgraded water body. So RM41 and therefore SG68 don't apply. So that's one document. Yeah.
Maybe it's not, I'm thinking about derogation in a different sense from what's being meant here, but is that a derogation from the standards that are required, or is that a derogation of what a person such as the appellants would have to do? I'm just trying to, it's probably me who's not following this, but this is a suggestion where action is taken because of a downgrading,
Yeah.
which suggests that more action is needed. But what I'm thinking about here is the situation where it may be argued that less action is needed. The reason why the appellants are in this situation is because they're entitled to take less action.
It's a very specific.
Yeah.
I don't know if derogation is necessarily a word, but that is what's used. But it's very specific under the Water Framework Directive to
So-
deal with where you've got that. You're looking to introduce a process or something to that water body that caused that downgrading, and effectively, so it's allowing that derogation the opposite way. You know.
That's
Goes
what
from
I'm driving at.
Yeah,
So,
because it's requiring
Yeah.
more action to be taken to bring it back, but it's looking at then what's done around that. It's not a in the sense of the derogation under PPC and the
No.
IED. That's allowing that lower limit to be applied.
So which document was that? RM41. What?
RM41's
It's
not
production
in
number.
process, but that's what what SG68 relates to. So
Relates
that's where
to,
we were
okay.
saying it doesn't apply because
That's why it doesn't apply.
RM41 doesn't apply here.
But I mean, the point's been made. I think I understand the point that it was referred to in correspondence. That's maybe
Yeah,
what's given
and
rise.
I think
Confusion.
again, just hold our hands up. That was just trying to. It goes through, you know, how you look at alternative options. Obviously, when we've got replacing a condition in a permit that requires treatment, you expect the operator to go through their own optioneering. So it was just really to assist in that process rather than saying this is a. There was no point that we were saying you're downgrading the water body. This is what you need to
So,
apply.
so you're saying that isn't what it is. Okay. The other document, is that also an RM document 34?
Yeah, yes, it is. Yeah, and yeah, what SG68 also supports what RM34, but RM34 only applies for new discharges, not for existing discharges. So it's not relevant in this case.
Okay. And would that be new applications for a permit, or new discharges, even for
New discharges.
for a permit holder? So if there's a new discharge that would arise for the existing permit holder, then RM34 would apply.
If it was a new discharge.
If a new discharge arises, yeah. Okay. Thank you.
I think maybe it's perhaps just useful adding just on that point as well that, you know, again, I think we've referred to it before, but if this discharge was a new discharge, it would be highly unlikely to be authorised.
Yeah,
Based
that's
on-
why I was
yeah.
wanting that clarification, because I was thinking back to what you said
Yeah.
earlier, and why I'm asking about a new operator and a new discharge. And if there's a new operator, I think your indication is it's not likely to be allowed to be permitted, but this is a new discharge more than likely with an existing operator. I think it'd be useful to try to draw some of this together in terms of the sort of respective views on the legal position here. I think we've covered virtually everything on the agenda by way of facts. If anybody has anything further they want to say, they can shout. So I guess what I need to go away and reflect on, and I'd like to do that having heard both sides in the time that we have this afternoon, is what the appropriate approach that should be taken by me in relation to the reconciling of these two positions, the the claimed failure to meet the EQS versus the very significant consequences Mr. Martin has explained, both environmental and financial, on the appellants, which certainly appears to be the sort of primary driver behind taking the appeal, and that's is what's become quite clear. It was clear before, but it's certainly clear from these 2 days of evidence. This is a matter of considerable grave concern to them in terms of their approach. So in weaving my way to find a way through this, and to be clear in my own mind as to what the appropriate approach I need to apply, I would invite, start with the appellants, invite their representations and their comments as to how they think I should approach this issue, and if there is anything in the papers, if there's anything that I could be guided towards, that I should look to for informing myself as to the correct approach in reconciling the kind of essence of this issue.
Sir, thank you for that, but without wishing to be unhelpful, I would require to spend some time to consider that and articulate my thoughts and put it down on paper. The matter is of some considerable complexity, I may say. With respect, however, you are right to introduce your remarks by saying the claimed failure to meet the EQS. Now, yes, there is a numerical failure to meet the EQS, but as I'm sure you appreciate, as I outlined perhaps not very eloquently yesterday, it's not accepted that the EQS is the appropriate standard to apply for a number of reasons. And that may well be relevant, and I suspect will be relevant when I come to put my thoughts down on paper in legal submissions relative to the other side of the coin and the consequences of requiring to meet or otherwise. Because first of all, one has to establish that there is that requirement to EQS. And if trace where that arises from, and if that is correct as a matter of law, whether it is then relevant as a matter of law for you, sir, to take into account. I'll shorthand them by the word proportionality arguments, but that perhaps encompasses a number of aspects, or whether, as I understand SEPA's position, is EQS is an absolute, no means for no area of discretion or wriggle room or proportionality assessment, which I think may be their position. And it may be, no pun intended, that's where the clear blue water between us lies or floats. If, as a matter of law, it's EQS we're looking at.
Yes, and I can think of at least 2 grounds in which you would say no.
Indeed. But then, as I say, if it does apply, then there are these separate arguments in relation to, is that an end of the matter? And do we just look at numbers? Stop. Or do we go further? My submission will be that you do go further. And just to flag up where I think I'll land, that will be through the fact that this is a PPC permit. The variation is under 46, which takes you back to Regulation 25, and 25.2 in particular. But as I say, that's just a preliminary view.
That's very helpful in shaping, because one of the things that is going to shape all of this, of course, is the further evidence. So not only can you not make submissions really because of the complexity of where we are, we're also not in a position where at least I have a full enough understanding of the ecology.
Indeed, sir, and thank you for reminding me of that, because SEPA was clear, although they're using ecology sort of as a make-weight argument, but they're looking purely at the chemistry, and we say you don't just look at the chemistry, and you look at the wider environment, including the ecological impacts on downstream.
Yeah, indeed.
And also in the immediate, what effect is this having, the exceedance over the EQS, what effect is that having on the unnamed tributary, which we say is not significant? And in any event, once you go slightly further downstream, it's insignificant. But again, these are legal arguments. I suspect SEPA may say, and if I'm wrong, they'll no doubt tell me, but I suspect they'll say, doesn't matter.
On that point, actually, when I read last night that the chain of emails about from 2022, I noticed that one of the emails there refers to Luggyburn as being 10 kilometres away, and I noticed that last night because I think somebody yesterday, probably me, said it was. I had a sense it was 6 kilometres, but I
think perhaps the figure that's been in the papers to date has been as crow flies.
Oh, I see. It may be that, but it is actually. It is actually.
I think
further away.
I have to trace it, but I think the Water Resource Unit talks about 5.8 or 6 kilometres, but
Certainly that order, which is obviously...
It's a significant.
Before asking SEPA to comment, and again, this is maybe something we simply can't deal with today, but as a subgroup of the dispute between parties, is in thinking about preparing for this hearing and more significantly the 4th of March, I certainly had in my mind the question of whether even if it were justified that there was a requirement greater than table 12, whether that requirement extended to everything that was required in table 13. That's a subgroup of the issues we've been discussing. I think I hope, if that's a potential approach, I hope I'll be further forward in thinking about that with the evidence on the 4th of March. But I just wanted to record the fact that as we're sitting today, that's still an issue in my mind. If that's the wrong approach or that's not the right way of looking at things, no doubt parties will tell me. But it is something that was in mind, listening to what Mr Martin was saying earlier on about the costs and other implications of RO, and I've heard some really useful and quite commonly shared views as to the alternatives. If the figures required in table 13 were different figures, if that were either possible or established on the facts to be relevant as different ranges, whether that might take us to a different place in terms of the way forward, which could mean either the figures in table 13, or it could lead to a place where you might say that the target date for achieving those might be different from what's there before. So I just flagged that up just to be open with parties and representatives, that was a factor that has been in my mind. I don't think we can take that much further forward today, but I just wanted to share those thoughts with
Perhaps if
parties.
I could just say that the evidence that's been held over to the 4th of March, the ecology evidence, will not assist you in that matter. So the table 13 limits have been based on the EQS, the data that we've already discussed over today and yesterday. So the discussion of the ecology evidence is not going to take us any further. And I would go so far as to say, and I've put this in correspondence prior to the hearing, was that the ecology issues really brought it to our attention, the issue. But beyond that, it has been the chemical data that has been the basis for our decision making here. So it's almost, I don't want to dismiss the ecology evidence, that's still important, but it's almost irrelevant to hear that evidence in a way on the 4th of March, because it's not actually going to the nub of the issue about how the basis for the table 13 limits and how we've calculated that.
May I?
Sorry, that is certainly understood, but the ecology was brought in the response, and it is relevant to the appellant's position, having regard to the bigger picture, which we invite the reporter to approach it in that way. But I entirely understand SEPA's position, and I don't think anybody around this side of the table is under any misunderstanding. But again, this is where there's a difference between the parties.
And
Well, I was just going to bring us back to the point that I made yesterday with regards to, obviously there's chemical inputs going into the environment, and the EQSs are giving us one measure, if you like, of the potential environmental impact of those chemicals being released into the environment. The ecological assessment is another marker of the ecological impact. So they are inextricably linked, but not, they can be looked at separately to some extent, in that they are different markers for the chemical releases going into the environment. So as I mentioned previously, the EQSs are based on ecotoxicological data, which cover a broader range of species that are looked at through the ecological assessment alone. So they are both relevant, but the EQSs are giving a sort of wider protection, if you like, of, to try and indicate the potential release of that chemical and the impact that may have. So they're kind of marking unseen effects that are not reflected in the ecological assessment alone. So I just wanted to bring that point out, that
And it's worth asking a question just now, just when I've got you here, is to what extent that approach that you've just described has been taken has an element of precautionary principle involved. Is there a degree of erring on the side of caution?
That's a foundation of all
In all of it.
environmental regulation within the EU and
Yeah.
within the UK. Precautionary principle is actually something that isn't really used in the US, which was an example of another regulatory regime. It is a cornerstone of risk assessment across Europe.
Yeah, no, I appreciate that, and,
Yeah.
and that's right. But I'm still interested in the extent to which that by taking a cautious approach and taking the precautionary principle, applying to that, that it seems to me is not without limits, in the sense that if an unduly strict approach was taken to the precautionary principle, that would potentially have the effect of imposing an obligation that's higher on the appellants than is strictly necessary. And there's maybe a very narrow, small difference between, hopefully small difference between those two things. And I'm conscious, and indeed I think we all accept the application of the precautionary principle, but that's not carte blanche for, if you like, excessive regulation, if you see what I mean. It's just that thought in my mind.
And
when you
again,
mentioned
that's not the basis that we've made our decision here. We've not taken a stricter approach because of applying the precautionary principle. So we've applied it on the existing standards, and I think when we talk about the issue of proportionality, it's this again reiterate the point that this is the approach we take across all of our authorisations. This is applied across the board. We've every point source discharge in Scotland we have assessed on this basis, and the argument about it improving further downstream and not having an impact on the Class 5, that's essentially saying we're on a race to the bottom. We can pollute as much as we like as long as we don't cause an impact to that classified water body, which is the complete opposite approach to what we have under water regulation and PPC, where it's really to prevent those discharges, and if we can't prevent them, to minimise them. And it's that, we're essentially questioning our whole approach to environmental regulation here by this appeal, which is ultimately, it sounds like the appellant's argument now is that they accept that RO is the treatment technology that's appropriate here. They use it on other sites. They have the budget for it. They have the space for it. They've considered planning. It's effectively all there, but they just don't think it's worth it for this piece of the water environment, which is, yeah.
This would be a last opportunity for anybody
Yes, thank you.
who wishes to either say anything by way of legal submission. I can take a few minutes to gather thoughts, or anybody from the effectively as witnesses or attendees who feel there's anything burning they want to say to me about the other issues that are going to be relevant to all of this.
So I wonder if I could just have a couple of minutes. Thank you. No, sir, for my part, I have nothing further to say at this stage.
Probably just to clarify, there was a number of things that we said we would do follow-up written submissions, so I suppose the procedure for that following today, and also just to clarify around the 4th of March hearing, I think you had indicated we'd have a bit of discussion around what format that would take.
I'm not particularly intending just now to summarise, because it's up to parties, not least because it's up to parties to say what they want to include in closing submissions and the like. But I know there are a number of issues that have come into focus and will benefit, I think, from seeing this written down, and that can be done. That can be done in due course. In terms of the session on the 4th of March, the first thing I would just repeat what I said yesterday morning is if any of the witnesses attending on the 4th of March are intending to refer in detail to this, the productions that are submitted, in particular those of an academic nature, if there's anything particular that it would be useful for me to be referred to in advance, so I can try to get my head round some of the terminology I've looked at already, but I think I'm going to have to work a bit to understand some of that. So as much of a kind of a heads up as possible would be useful. Partly related to that, I guess, is if parties are in a position to update the joint minute of agreed facts, because some things have moved on. If that were able to be updated, that would be quite useful. In terms of the process and arrangements for the 4th of March, which are planned to be in the same location, same basis as we're dealt with today, I had reserved my view as to whether this process should be elevated as a formal sort of inquiry session. I'm not inclined to do that, I think, but if I have the precognitions, which I know are unusual for a hearing, but are immensely helpful to me, to be looking into these things and try to ensure this can be as open structured a discussion as possible. So I won't be looking to agents to be particularly leading their witnesses through in a traditional way, but nevertheless I'm very open and would very much welcome if agents were happy to effectively help the witnesses structure the evidence that's taken forward, and I'll be very open to allowing questions of each other's witnesses when we come to the 4th of March. What I haven't given any thought to really is the question of the order in which witnesses should attend. Should give their statements. We can think about that between now and then. And I also am aware of, but I've not myself given any thought as to whether it might be helpful for me to try to do a restructuring of the remaining part of the agenda. That may be a task that I could undertake, and obviously that would be for adjustment between us to find the best way. Once I've read and reread the precognitions, the agenda italicised for today, the things that are held over.
That was going to be my question, whether it was purely the 2 items on the agenda relating to ecology evidence, given that I think Mr. Martin had also lodged the precognition, so it was just whether there's any expansion of the scope of what we're covering on the 4th of March, or if we're keeping it purely to the...
No, absolutely, and I see that, for example, item 3.7, the good quality status of the Luggy water, and I was grateful for being directed to the documents that contains information about that. That may even not need to be on the agenda now, but I think my suggestion is that I try and adjust or create a freestanding agenda for the 4th of March.
So one question which does occur to me, and obviously I wasn't present on the site visit, and you may have a chance to read the ecology reports. I'm not sure the extent to which you actually saw the various points which are referenced in the ecology reports, and whether there might be merit in dare I say, a further site visit. But I'm actually ambivalent about the matter, just to inform yourself.
Yeah.
I'm also reminded that I think, sir, when you visited, it was pretty dormant, it being around winter time, and
it was by 8th of October or something like that. Memory serves
it's just
correct.
a suggestion.
The seasonality point, of course, it's a fair point actually. I mean, we'll be not quite into spring, but we'll be into a certain different season. So 70%. But I don't know the answer to the question about whether I've seen the same sites at the ecology reports. I've not read them in that detail. You've heard the information about what sites I was present at. I'm not against the idea of going out on site again in the period before or in around the time of the adjourned hearing. If it's planned to do so beforehand, that might prove quite difficult. I think I might be able to do it kind of immediately beforehand, but I'm away in the middle of February and will not be available at that time.
I've no difficulty with it being before or after the 4th of March.
Yeah.
As I say, it's merely a suggestion. It might help to put into context either before you hear the ecology evidence or indeed fairly shortly afterwards.
Yeah, it may be not a bad idea.
We wouldn't have any objection to another site visit if that's what you felt necessary. I mean, we did
I know
have
where I'm going.
an
I've been there
extensive
before.
site visit the last time, and I think
It was.
we did visit all the
Yeah.
points downstream that are referred to in the ecology reports.
If we have, you think we
Yeah.
have visited them? Well, we can play that by ear, I think, depending how we go for that.
Again, in terms of choreography, if I might describe it that way, of the session on 4th March, it is the ecology witnesses. I tend to agree with you, sir, that a more open session by way of hearing session is appropriate. It may, rather than a formal examination, cross-examination, re-examination, it may be that we're sort of looking at a hot tubbing type situation. But perhaps parties, and indeed you, sir, we can give some thought as to how most effectively to hear that evidence.
Yeah, I'm happy to do so. And the only last thing that I'm just thinking in terms of issues for resolution, and we can deal with this on the 4th of March, maybe again after evidence is heard, is the question is that if the appeal were not to be allowed and the 31st March date of 2027 was to remain in place, perhaps the parents can give some thought to the question about what that means in practice for the feasibility of achieving that date. Because as I've recognised already, that sounds like that would create significant challenges. And I wouldn't like to have a situation that they fall effectively into inadvertent breach by failing to meet that deadline. Now, CBA would have a view on that as well, because they have obligations to meet to ensure that quality is met expeditiously. But I'm just conscious that date we're now kind of careering towards it, and it may take me some time to write this stuff up.
Certainly, I think if there was any discussion around that on the 4th of March and looking at the ability to meet that date, that we would be looking for further for justification to be provided of any future date that they were putting forward at that stage, given that, you know, as I've said before, that they have this right of appeal, but the condition has not been suspended, and we should always be planning still to the should they be unsuccessful in the outcome of that appeal. So we would be looking for strong justification of that.
Let's address that. Well, how
Yeah.
realistic that is, the circumstance of a live appeal on.
Yeah.
Let's
And
not get ahead of ourselves.
yeah, if I could just confirm, so on the 4th of March, you would be looking for closing submissions from both sides on
On a date to be decided.
on a date to be decided
At the end of that
in
session.
person or written. Right,
I have
written.
to have,
Okay.
have to have it in writing, and again, parties can think about what the appropriate length of time is. There may need some thought to be given to that, and I know we know other commitments involved in that. My own practice when seeking closing submissions submitted later is.
And just in terms of the submissions that we were going to do before now and the March hearing, would you have any, or just when we're able to do those? For the submissions that I was going to give some follow-up submissions in terms of the application of the EQS.
I suppose I'd imagine that to be all dealt with closing submissions as one lump sum at the end, rather than dealing with dribs and drabs of submission.
If that's all right to the appellant, I'm more than happy to. It was just whether they
I don't have
wanted
any
to
strong
see that in
feelings.
writing, that full
Yeah.
argument that we haven't
Yeah,
made previously in our
absolutely.
submissions.
If that gives you more time to compile it as well, because it obviously is quite complex.
That's fine, sir.
Okay, well, thank you. That's been very illuminating. Yes, these appeals always are in different ways, and so thank you for your submissions, your evidence, and your good-natured addressing of the issues arising in the last day and a half. Thank you.